We have with us our tutor in the name of Stool Esquire. In fact, I believe many of you have heard the brand Stool, on his social media platform, that is the X platform. Stool, as rightly indicated, is a member of the Ghana Bar. He has practiced for a period not less than 3 or 4 years. Indeed, he is a research assistant to the Conference of Law Deans, and also in 2024, he founded the Legist Research Consult, a student-focused initiative promoting academic writing, legal research, and access to quality legal resources. On 1st October 2025, at the beginning of the new legal year, Stool intends to launch the DOE Legist Law Consult of Corporate and Research, and intends that initiative or the firm will specialize in regulatory compliance, data privacy, artificial intelligence law, corporate due diligence, and commercial ADR. So, simpliciter, our tutor, as I've read his profile, has enormous understanding of the law. He has contributed his quota to the whole law space, as it being a volunteer in sharing his knowledge on existing legal matters that arises in this country. So, fellow, I am privileged myself as the Vice President of the Kumasi campus of the Ghana School of Law to have the privilege and the honor of introducing our tutor for the day. Our tutor for the day, as I rightly indicated, is in the person of Stool Esquire, and he will be taking us to immovable property. So kindly, class, let's enjoy our senior Stool take us through the rigors and the rudiments of understanding all that needs to be known in respect of immovable property. Whatever be the case, it is my greatest wish that come somewhere October, many of you, if not most, or if not all, will join us. And please, in choosing campuses, kindly choose the Kumasi campus, because this year, the Kumasi campus intends to make the whole law experience or vibe a different one. You have heard of the name Banks, and indeed, I am your vice president for the Kumasi campus. Thank you.
Thank you very much, Banks. So now we'll hand over to Senior Seth. Senior Seth, please, you can take over and begin your class. Thank you very much.
Thank you very much for this wonderful opportunity. Please, can you all hear me? Is my
Yes,
voice
please.
Loud and clear.
Yes, we can hear you.
Yeah, we can hear you.
Awesome.
Cancel.
Yes. I want to share my screen. It says only the host can share in this meeting. Can I be made maybe a co-host or something? I want to share some of the important information I have. I would speak a bit fast, and I believe students should have access to the screen so that you'll be able to get some of the authorities I'm referring to. I hope you got me. So, yes, I think I've been made host now. So let me see if I can share my material. Please, can you see my screen and maybe sharing or something? Can you see it?
We can see very well.
All right.
Yes, please. Yes,
Perfect.
please.
So I think this one will be very helpful, right? If you see it this way with the authorities, right?
Very much so.
All right. Is the volume too low? I think the volume is low. Is it better now?
Everything is perfect.
Perfect.
Everything
Okay, so
we
let's
can hear
start.
you well.
Yes, so I'll be
All right.
taking at least 3 hours of your time, so I'd like to move a bit fast. But then all the authorities are in here, and sometimes when I'm referring to a case, you could see it on the screen. I think when I'm scrolling down or upwards, you could also see me scrolling down, right? Okay, so let's start. So there are we are going to treat about at least 10 sessions under land law, right? There are certain important topics you have to, have the foundation under land law, because I know it's also referred to as immovable property law. Now, in these entrance exams, right, you'll be examined on either first semester, second semester topics. So we have, Allodial title, the Usufruct, compulsory acquisition, management of stool property, management of family property, and all that. But trust me, I'm here to tell you the truth. This is what you need to know, that in any land law question, right, there would surely or very likely be a constitutional basis. You have to be very grounded in your constitutional law. And I'm making reference to land law and the Constitution. Now, the Constitution has provided certain important provisions in relation to land law, rights in relation to land, administration of landed property interests. So let's have a look at it. So to appreciate land law, you need to understand the major constitutional provisions relating to land rights and management, right? So Article 18, the famous Article 18, everyone has the right to own property, either alone or in association with others. So with respect to Article 18, you know that the property in there can be movable property or immovable property. Now, immovable property is what you are studying, right? So everyone in Ghana has the right to immovable property. The foreigners have the right to immovable property, but there are some restrictions to it. You know that for foreigners under Article 266 of the 1992 Constitution, don't worry, I'll come to that. You know that foreigner land rights are restricted, right? So although you have the right to own property, foreigner land rights are restricted. So you are starting. Can you hear me?
Yes, please. Yes, please.
All right.
Yes, please.
So I'm moving a bit fast, but any authority I mention is already in this material. So you would see what I'm referring to. So I said Article 18, the right to own property. Now let's just move on. So I put in some authorities in there. For this point, it's not really relevant. You are just understanding that the basis of land law is under Article 18, right? The right to own property. Now, the case of AJ and AJ, a recent case decided in 2021 by still a landmark decision, the court held that even a spouse, though married, can own property, but individually. I hope you got it. So a spouse can own property individually. I think I've been moved as host, so it's not sharing anymore, right? But then let's move on. So a spouse can own property individually. That means that you can acquire property, right, even when you are married, because there's a presumption that two or more people when they are married as spouses, right? These two people, when they acquire property after marriage, is deemed to be what? Is deemed to be joint property, jointly acquired property. So we'll come to that. But I'm just letting you know the foundation. I hope you got it. So I'm going back to sharing my iCloud drive. Let me see. All right. Perfect. So I referred you to a J and J. You can read it in there. It talks about a private person's right to own property. Now, apart from owning property, you can also have an interest in land. Even a trespasser who is in possession of land can have an interest in land. Remember the case of Owedu and Mim Timber, where the court held that a person in possession of the land, though himself a trespasser, is entitled to maintain an action of trespass against any person who disturbs his said rights or said possessions, right? Said possession, except the person in whom title to the land was vested or its agent or representative. So the point is that under Article 18 of the 1992 Constitution of Ghana, we have the right to own property, and it is movable or immovable property. So what you are going to deal with in this particular session is immovable property. Now, the right to own property is subject to the public interest under Article 12 of the 1992 Constitution, and also respect for the rights of others. I hope you remember that. So, Article 12 is a very foundational provision, right, dealing with human rights. So every right is subject to the public interest and the respect for the rights of others. I'm starting from a very, very important foundation. So I hope you join us. I hope you are in tune with what I'm saying. So Article 12, public interest, respect for the rights of others. What is the public interest? How can our land rights be restricted in the public interest? For example, compulsory acquisition, right? So although we have the right to own property, the state can compulsorily acquire our property under what? Article 20 of the 1992 Constitution. Do you remember Article 20 of the 1992 Constitution? Now, although everyone in Ghana has the right to own property, what about foreigners? The rights of foreigners are restricted. I hope you remember that. There is a whole topic about foreigner land rights under what? Article 266 of the 1992 Constitution, Section 10 of the Lands Act. So yes, we all have the right to own property, but who is a foreigner? A foreigner is someone who is not a Ghanaian citizen. So when the foreigner is staying in Ghana and wants to own an interest in land, he's not entitled to own a freehold. Remember that, a freehold. We'll come to freehold later. You know that under Section 1 of the Lands Act, there are what? 6 landlord interests. I hope you got it. So we have the Allodial title, the Usufruct, the customary law freehold, the common law freehold, the leasehold interest. We also have the customary tenancy. You get it? So it's a foundation. We are starting from the foundation. And I'm letting you know that in case you are solving a land law question and it's on leasehold interest, we have the right to own property. That's the foundation. You need to start from the Constitution. Remember, Article 11 of the 1992 Constitution of Ghana. The law, right? The sources of law in Ghana. The Constitution, right? That's our 1992 Constitution. The Lands Act, that is Act 1036. That is the statute, right? Apart from the Constitution and statute, there are what? Subsidiary legislation. What are some of the subsidiary legislation? The High Court Civil Procedure Rules. I hope you got it. So it's very straight to the point. The High Court Civil Procedure Rules, CI 47, right? It's a subsidiary legislation. It's also applicable in here. Do you remember? So you come to that later on. And then we also have what? The existing law. Give me some examples of existing law. We have, PNDCL 114. That is the Family Head Accountability Act. Under Section 13 of the Lands Act, there is reference to what? The Family Head Accountability Act. Why? Because that is dealing with the fiduciary interest. I hope you remember that. We'll come to all these. I'm letting you know that the foundation is from the Constitution. When you're talking about the Usufruct, Constitution. When you're talking about the Allodial title, Constitution. When you're talking about foreigners' right to own property, Constitution. When you're talking about spousal rights, Constitution. When you're talking about, acquiescence or adverse possession, Constitution. You get it. Always start from the Constitution. What does the Constitution say about this? What does the Constitution say about that? Because if they are marking your authorities and you begin, expressing your law from the Lands Act, but there's a constitutional provision that is applicable, you've missed the point. Because the Constitution is the foundation under Article 1 Clause 2, right? The Constitution is the supreme law. So any source of law you are going to apply, make reference to the Constitution, unless clearly there's no, provision in relation to the Constitution, in relation to that particular subject matter you are going to write on. But trust me, there will be. Trust me, there will be. So you better memorize the constitutional provisions that deal with land interest, right? So let's quickly move on. So, under Article 36, Clause 8, right? So I've mentioned certain important constitutional provisions that you can have a look at. It says compulsory acquisition, Article 20, restriction on foreigners' rights, Article 17, Article 266. Why Article 17? Remember, everybody in Ghana is equal before the law. No person shall be discriminated upon. So a foreigner should not be discriminated upon, right? But the Constitution says there can be special laws in the public interest that can restrict the foreigner's right to own property. Check out Article 4, Article 17, Clause 4. Also, yes, check out that particular provision. In case you are not sure, simply say Article 17, pardon me. Simply say Article 17. Don't try to give clauses or sub-clauses if you are not sure of the particular provision. So you make sure that it starts from the Constitution, your authorities. It starts from the Constitution, right? So this is not a topic, right? This is just the first session. I'll just use 10 minutes to gloss over this point. But I'm making a very important emphasis here. You don't start Allodial title by starting from the Lands Act. No, you start from the Constitution, right? You don't start Usufruct from the Lands Act. You start from the Constitution. The Constitution is the most important authority. It is what will carry you the most marks, followed by the statute, that is the Lands Act or the Courts Act, any particular law like the Rent Act that are applicable. If you miss the Constitution and you jump straight to statute, or if you miss statute and you jump straight to case law, trust me, you are losing the marks. Do you get it? Because case law, that is the common law precedent, under Article 11 is what the fifth option. Remember, the fifth alternative is down there, right? So we have the Constitution, we have the statutes, and all those particular relevant sources of law. Then we have the common law, which consists of customary law, equity, and what? The common law, that is the precedent. I hope you got it. Right. I think someone is joining on the screen. Oh, all right. So I've just made certain references in there. So for example, Allodial title, Stool lands. Look at Article 295 of the Constitution. It defines two lands. Look at Article 267 of the Constitution. It says, all stool lands in Ghana shall vest in the appropriate stool on behalf of and in trust for the subjects of the stool in accordance with customary law and usage. So when I'm going to look at the allodial title vested in the stools, the stool land or skin land, you don't start from Section 2 of the Lands Act. No, you go to what? Article 267, that all stool lands are vested in the appropriate stool. For who? And in trust for who? Right? The subject of the stool. So the subject of the stool are what? The usufruct. Right? The subject of the stool are the usufruct. These are the beneficiaries. So anything dealing with allodial title and usufruct in relation to stool land is what Article 25 and Article 267 of the 1992 Constitution. I've checked. I'm not the one joined on the page. So who is our culprit here? Because I'm checking it out. I'm not the one joined on the page. So, all right, let's move on. Now remember public lands, right? Public lands. When land is vested in the state or in the president on behalf of the people of Ghana, when land is compulsorily acquired, under Article 20, it becomes what? Public land. I hope you got it. It becomes public land under what? Article 257. So all public lands in Ghana shall be vested in the president on behalf of and in trust for the people of Ghana. Right. You can have a look at the case of New Omambo and Attorney General and the Lands Commission. Can you hear me? Are there some issues?
No, please, we can hear you
We can hear you
clearly.
clearly.
Cancel fire.
Please, the one
Fire on,
writing the
fire on.
screen,
We are
please
enjoying
stop.
it. Fire on.
Locust
All right, so
plus.
let's quickly move on. So, as I said, the case of me, Omabo, and Attorney General in the Lands Commission. Remember, he brought an action claiming that the land was vested in Nkrumah all the way back in the 1960s, and Article 267 says all stool lands shall be vested in the appropriate stool. So he brought an action claiming that, okay, my land was stool land, it is supposed to be vested in the appropriate stool. So can you now vest the land in the appropriate stool? But the court held that nope, it was public lands. It is public lands before the coming to force of the 1992 Constitution. So when they refer to stool lands, right, they refer to stool lands as at the time of the 1992 Constitution. Remember, the 1992 Constitution came in force, I think, on 1st January 1993. So there are a lot of relevant constitutional provisions. We have Article 18, right to own property. Article 12, every right is subject to the public interest and the respect for the rights of others. Article 20, compulsory acquisition. Article 22, spousal rights, very important provision. Article 267, stool lands. Article 266, foreigners' interest in land, right? You know there are some restrictions against foreigners. Article 257, right? Public lands, right? You get the point. Article 36 clause 8 is a very important provision. So, in all these particular pointers that I've mentioned, go and write them down, go and study those provisions, because the foundation of land law are based on those important constitutional law provisions. Article 295 explains the public interest. Public interest is anything that inures to the benefit of the public. I hope you got it. Anything that inures to the benefit of the public. I think this material is on the Google Drive for my students, so they'll be able to access it. I think for now, let's just rely on what's on the screen, although there are some interruptions. Right. So, we are going on to section 2. You see, I'm done with section 1. The point under section 1 is that pay attention to Article 18 of the Constitution, Article 12 of the Constitution, Article 20 of the Constitution, Article 22 of the Constitution, Article 267 of the Constitution, Article 257 of the Constitution, Article 36 clause 8 of the Constitution, Article 266 of the Constitution. Pay attention to those provisions. Pay attention to those provisions, because if you miss it and you start from the Lands Act, you are missing a mark in there. Do you get it? Right. So just write the articles, just go and study it on your own. I hope you got it. Let's move on. Now, what is land? Right? I'm not going to read that long Latin phrase. Basically, the point is, whoever is the soil, it is theirs all the way to heaven and all the way to hell. That is the principle, right? Under common law. Right. So, what is the principle under common law? That if you have an interest in land, or if the soil belongs to you, it is yours all the way to the heavens and all the way to hell. This is dealing with the airspace, the surface soil, and the subsoil. But you know that this particular point is a foundational precedent rule, right? It must be reasonable. So you cannot obviously own the airspace all the way to heaven, right? Now, what is land? Right. Now, if you want the definition of land, you now move to what? Section 281. Hello, I've been muted again. What's happening?
We can hear you.
We can hear you.
Yes, but I think I've been moved as. Can I be made a
As a
co-host?
host.
Let me. Oh, it won't work. Okay, let's move on. Someone else has taken the host position. What's happening?
Yeah,
Where are
but
the
we can hear you.
All right. So I want to share the material, but I'm not the host.
Yes. No. Share the material.
Yes, you have to share the material.
No, I cannot share because only the host can share. So can I be made co-host or something?
I said, please, I'm working on it. Just
You can share the link.
Sure.
Share
Okay, so
the
let's
link.
just move on.
Share the
Because
link.
I've made a co-host now.
Tika, please don't share this class.
All right, let's move on. Please, no interruptions. We don't have time. We are done. So please, I'm pleading with you. This will come. Article 18 of the Constitution, Article 12 of the Constitution, Article 20 of the Constitution, Article 22 of the Constitution, Article 266, Article 295, Article 257. Those are the articles I've mentioned. Those are the relevant constitutional law provisions. I hope you got it. Right. So now the principle of immovable property is that everything pertaining to immovable property is connected to what? Land. Land is immovable property. So it's not only the physical soil you see, it's also the airspace above the soil. It's also the what? The subsoil. So what is land? Section 281 of the Lands Act. Please, I'm pleading with you. That is the most important provision under the Lands Act. Go and memorize it. Section 281 of the Lands Act, right? 1036. It says land includes the solid surface of the earth, the trees, the plants, the crops, other vegetation, a part of the earth surface covered by water, any house, building, or structure whatsoever, and any interest or right in to or over immovable property. You get it? Everyone has the right to own property, right? Article 18. What is property? In reference to land, it is immovable property. It includes the right in the immovable property or the interest in the immovable property. What are some of the interests in immovable property? Section 1. Number 1, allodial title. We also have the Usufruct. We have the customary law freehold. We have the common law freehold. We have the customary tenancy. You get the point. So you start from a foundation. Article 18. Everyone has the right to own property. Property includes immovable property under section 281 of the Lands Act. What is immovable property? It also includes the interest, that is land, the interest in land, the plants, the buildings, the structures on the land. It can also include the topsoil. Pay attention to Article 257, Clause 6 of the 1992 Constitution. Write it down, 257, Clause 6. You know that every mineral in its natural state in the soil does not belong to the one in possession of the land or the one who holds the interest in land. It belongs to who? The state, vested in the president, the natural minerals. What is the act? The Minerals and Mining Act, or the Mining and Minerals Act, whatever. You get it. Just make reference to it. So it means that although we have the right to own property, although we have the right to own land, we do not have the right to the minerals in their natural form within the land. The gold, the bauxite, the diamonds, whatever you find within the land, as natural minerals, you do not have the right to it. It belongs to the state. You need a license, right? We will come to that later on. So, Lands Act, the most important provision, Section 1, Section 281. Is it 281? Yes, Section 1, Section 281. Right. So if you are dealing with trespass to land, I'm sure your tutor taught you trespass to land, right? Under tort law, right? So any interruption or interference with the airspace, like Kelson and Imperial Tobacco Company, the case is in there. Can you see it? They mounted a signpost. So when they mounted the signpost, it entered into the airspace of the neighbor. The neighbor sued. The court held that is trespass to property. You don't mount a signpost to enter into someone's airspace. Do you get it? It's in there. Lord Bastin of Lay and Sky Views. There was was it a June or something taking pictures over the land, and he sued. The court held that although you have the right to the airspace, it must be a reasonable proportion that is necessary for your enjoyment of your privacy. Satellite devices, drones, etc., right, are too far above the planes. They are too far above your land for you to sue them for breach of your airspace. I hope you got it. Putney and Clayton, go and have a look at the case. You can have the land right, but it doesn't entitle you to the what? The right to the subsoil. So there is what? The solid surface of the earth. There is what? The subsoil. There is what? The airspace. Pay attention to those things because it's in the Land Act. But in Ghana, the subsoil is restricted. The subsoil, the minerals in the subsoil belong to the state. It belongs to the state. You get it? Right. Let's move on. Now, of course, I made reference to Article 18, protection of privacy of home and other property, that everyone has the right to own land, right? Either alone in association with others. So we got it, own property, pardon me. So obviously, any interference with your land rights is what? Trespass. And I'm sure your examiner, your tutor took you through trespass to land and that taught law. So I made reference to Article 257, Clause 6, right? I've made reference to it already. Section 281, I've also made reference to it already. You saw it. So that is it. We are done. So what is land? Land under Section 281 of the Lands Act states is basically what? The surface soil, the airspace, the trees, the buildings, the structures on the land, and anything that is within, apart from what? Our mineral rights. And then also the interests, right, connected to the land. What are the interests? We have the allodial title, customary law freehold, common law freehold, customary tenancy, the leasehold interest, and the Usufruct under what? Section 1. But the foundation is what? Article 18 of the 1992 Constitution. Now we move on. Now we have the right to own property. We have the right to land, right? Immovable property. You can hold an allodial title, customary law freehold, common law freehold, Usufruct, all those particular provisions. Remember, all those particular interests. Remember what? Section 1. Section 1 of the Lands Act. You are not supposed to forget it. It's the foundation. Once there's a question on allodial title, Section 1 of the Lands Act, Section 281. Once there's Article 18, Section 281, Section 1. Once there's a question on Usufruct. Usufruct is in Section 1 of the Lands Act. It's also in Section 281 because it is an interest or right in immovable property. The Usufruct is also what? Provided in the Constitution. Everyone can own land, right? You can own a Usufruct. You can own an interest in land. Usufruct is also under Article 36, Clause 8 of the 1992 Constitution, right? Fiduciary duty of the chief or the family head in relation to stool land, family land and all that. Article 20. Now we are moving on to Section 3. We are doing 15 sections tonight. And I know I'm moving a bit fast, so I want to be better. I want to provide you with the materials so that you don't start crying. You get me? So Article 20 of the 1992 Constitution, compulsory acquisition. What is compulsory acquisition? When you read the question and you see that the area of law is compulsory acquisition, or it's an essay on compulsory acquisition, please, 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 do not start from Article 20. Start from what? Article 18. Article 18. Everyone has the right to own property. Now, that means that no person can interfere with your right to own property unless it's in the public interest. Article what? 295. Public interest. Anything that inures to the benefit of what? The state or the society or the people of Ghana. Now, you move to Article 12, right? It means that every right, including your right to own land, is subject to the what? Public interest and respect for the rights of others. Then you move to Article 20. In the public interest, the state can compulsorily acquire your property. Simple. So on compulsory acquisition, any particular question on compulsory acquisition, start from Article 18, right? Then you talk about the restrictions. Article 12, it can be restricted in the public interest, respect for the rights of others, right? Two main restrictions. So although Article 18 gives you the right to the property, public interest comes in. Public interest is defined under what? Article 295, it defines public interest. Then you jump to what? Article 20 of the 1992 Constitution. What can you take from compulsory acquisition? Emphasis is on public interest. You get it? Right. So compulsory acquisition can only be made under law because the law will reflect the public interest. Remember, so the law will state the public interest reason for the compulsory acquisition. And you know that the reason the state acquires your land in the public interest must be greater than the hardship that will be caused to the private individual who has an interest in the land. You get it? Look at Section 2, allodial title. When the state compulsorily acquires your property, the state acquires the allodial title. That means that whoever owns the allodial title, his or her right has been extinguished. That is what calls for the what? Payment of compensation. So you must pay the person what? Compensation promptly. Prompt payment of fair and adequate compensation. Why? Because you are depriving the person of his interest in the land. You get it? So it is public interest. Public interest, so important. So the public interest is not based on Article 20, it's based on Article 12. That your rights can be restricted in the public interest. Then Article 295 explains public interest. Then Article 20 also gives some, some provisions in relation to public interest. And then
Solodan,
there are
please
things that
mute yourself.
please mute. All right, let's continue. So I gave 10 rules. Don't go and do 3 and 4. Just understand, right? Compulsory acquisition can only be made under law. That is what an executive instrument explaining the public interest for which the land is being compulsorily acquired. The acquisition must be communicated to the lawful occupiers of the land. That means that before you acquire the property, at least communicate it. Usually, the state to gazette, right? They will publish it in the gazette, the EI, the executive instrument. But of course, before they acquire the property, there should be some communication, some notice, some consultation. Inform them that you have an interest in that particular property. Do you get it? Right. The acquisition, okay, I've said that already. Number 3, the public interest reason the state must. So the public interest reason for the state must override the private interest of the lawful occupier. The lawful occupier, that's the one in possession of the property or the one who has an interest in the property, must be promptly paid fair and adequate compensation for the land. Do you get it? The lawful occupier can be given appropriate alternative land in exchange for compensation. Right. The lawful occupier will retain the first right to repossess the property where the state is done dealing with the property in the public interest. Pay attention to this. Thank you. Let's jump. Now, of course, compulsory acquisition, right? It's not the only means by which the state can acquire your property. People forget that. So that is the trick. That is the twist. You get it? That, the state can only acquire your property under compulsory acquisition. Pause. No, compulsory acquisition is where the state acquires the property in the public interest for use for the public benefit. But there are other means by which the state can acquire the property. You get it? Right. You can commit offenses, fraud, stealing, and you build a house, you buy property, right? Then the state will confiscate that property. Why? Because you used it, you bought it using what? Proceeds from crime. So offenses, it's in there, right? Civil debt compensation. The state can order a seizure and sale of your property because you owe money. Remember, Herman and Kofi, you cannot be imprisoned for a civil debt. You remember that case, Herman and Kofi, where a contractor owed money to certain clients. They reported him to the police, and then the police arrested him, and then they threatened him. They put him in prison, so they threatened him that if you don't sell your property, we will not release you from prison. He sold the property. Then he was released. He quickly brought an action to the court to nullify that particular transaction. The court said that you do not arrest and imprison someone for a civil debt. You get it? Very, very important. I'm sure you had treated this particular case under Article 14, right, of the 1992 Constitution, right? So maybe under tort law, or we also treat it under human rights. So pay attention to that. Very important. So when you owe a civil debt, the state can actually compel a seizure and sale of your property to pay off the debt. So yes, that is another means by which the state can acquire and sell your property, right? So of course, you can have voluntary abandonment. So the point is in there that a person can die. For example, someone can die in Ghana with no trace of any family member. He's the last living person or last living member of his family. He has the property. There is no will, intestate succession. There's no one. There's no spouse to transfer the property to. You know that it can revert to the state. You get it? Now, there's also involuntary abandonment by a foreigner, right? Pay attention to that. When the 1969 Constitution was passed and came in effect on the 22nd day of August 1969, it stated that now you cannot have a freehold of what? A foreigner cannot have a freehold of, cannot own a freehold. So every freehold is truncated to a 50-year lease to be paid at perpetual rent. And then at the end of the 50 years, it will revert to the state. I hope you got it. So pay attention to that. When I say pay attention to that, pay attention to that. Now, if you look at Section 233 of the Lands Act, so you see, you start from the Constitution. When there's a question on compulsory acquisition, and it's likely to come because you see, compulsory acquisition deals with what? The Constitution. It deals with what? Public interest. It deals with what? Land rights. Do you get the point? So when there's a question on compulsory acquisition, start from the Constitution. Talk about Article 18, Article 20, Article 295, Article 12. You get it? Emphasize the public interest. Then move on to the Lands Act, Section 233 of the Lands Act. That is the foundational provision on compulsory acquisition. Every other provision, right, is supportive. It's a supporting provision. But the main provision is under Section 233. So if under the Lands Act, remember Section 233 is enough. You get the full marks. You get it. Section 233 of the Lands Act. So it says the power of the state to compulsory acquire land for public purposes. The states may compulsory acquire any land, where the acquisition of that land is necessary, for a public purpose and in the interest of defense, public safety, public order, public morality, public health, town and country planning, resettlement purposes, or for the running of essential services. They've listed some of the public, interest reasons for the acquisition of the land. But the mere fact that the land is being acquired in the public interest doesn't necessarily mean that it is justified. No, the state must justify the use of that particular land. Do you get it? The state must justify the use of that particular land. So it is in the what? Public interest. Right. Let's move on. So that means that the justification is that the benefit the use of the land would, give the state is more than the hardship that will be caused to the private individual. So number one, public interest. Number two, reasonable justification. Number three, payment of compensation or granting alternative land. Number four, what? The land can revert to the previous owners. They have the first right of re-entry or whatever. You get it. It's under Article 20 of the 1992 Constitution. Don't try to say Article 20 clause 1, Article... No. Just say Article 20, you are correct. Because if it's under Article 20 clause 1 and you say Article 20 clause 2, you are wrong. You get it? So just say under Article 20 of the Constitution. If you don't remember Section 233 of the Lands Act, say under the Lands Act and you are good to go. You might not get the full point, you just get half mark, but then it's better than saying under Section 265 when it's Section 233. You get the point? So I entreat you to, just note Section 233. All the other sections I've placed in there are what? Supporting provisions. Right. There is also vesting. I'll quickly skip over it. Time element, you can read it. Blah, 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 blah. The material will be shared later on. Now, the case law. Case law is very important. Need to be Tetetu and Attorney General. Samuku Jeto and Lands Commission and Jacob Bechibi. Memuna Amudi versus Mr. Kofi Entry. Nim Omabo and Attorney General. Yakubu Arebigo versus Tindana Agungu. Now, I've put those cases there for a reason. Please go and read them. You don't need to read the full cases. You can read the briefs. You get it. Now, let me just give you some pointers. Nipo Bitetetu and Attorney General. So the court took the view that the expression public interest, right, should be given a wide, broad, liberal, and expansive interpretation. If, therefore, the state decides to acquire the land for the public interest under Article 20, the state can still use the same land for a different purpose, as long as it inures to the benefit of the state. Go and read Article 20 very well. It says they can use the land for that purpose, or they can use the land in the public interest. Emphasis on or. So it is disjunctive. That means that even though the state is not using the land for the purpose for which it acquired the land, the state can still use the land in the public interest and to still be justified. You get it? So sometimes they can acquire the land, la wireless station lands, and then later on they'll use it for the construction of buildings for Ghana 50. Now the court is saying that it is in the public interest. They are both in the public interest. So although the land is being used for a different purpose, it is what? In the public interest. Pay attention to Nipo Bitetetu and Attorney General. Anything concerning public interest, this is the landmark principle. The public interest can change, but as long as it inures to the benefit of the individual, it is in the public interest. I hope you got it. Now, Samuku Jeto and Lands Commission and Jacob Bechebi Lamte, right, is down there. Same principle. Samuku Jeto brought an action that this land that has been acquired in the public interest was granted to a private individual to develop for a state housing project or affordable housing project. The court held that, yes, that is correct. It is in the public interest. It also dealt with Article, 296, discretionary powers and all that. So the Lands Act has the discretionary authority to determine what to use the land for in the public interest. Simple. Right. There's also Ni Omambo and Attorney General, Lands Commission. Remember that when the land is acquired in the public interest, it becomes public lands. It is no longer stool lands. So yes, Article 267, all stool lands shall vest in the appropriate stool. Yes, that is true. But once the stool land has been acquired by the state, Section 2 comes in. Section 2 says that the allodial title can be acquired by the state by what? Compulsory acquisition. So now, when the allodial title is acquired by the state, that means that the state becomes the allodial title holder. It is no longer stool land, it is no longer family land, it is no longer clan land, it is no longer individual property, it is what? Public land. It is managed by the Lands Commission. If there are people on the property who are still paying rent, they'll pay the rent to the Lands Commission. If they have to, sometimes they'll remove all of them from the land because they want to use the land from the public for the public purpose. You get it? Right. Memuna Amudi, right, versus Mr. Kofi Entry. Court held that the property no longer belongs to the plaintiff since the land was compulsory acquired and all the plaintiff's interests or rights were now vested in the state. What happened? He was the landlord, supposedly, and they were paying him the tenancy, they were paying the rent and all that. But then the property was compulsory acquired by the state. And he was still charging rent. And then the matter went to court. The court held that no, when the land has been compulsory acquired by the state, even if they've not started paying you compensation yet, but they are making provisions for it, as long as the compulsory acquisition occurred on this date, from that day onwards, the land is public land. You don't charge rent in your own benefit. It is public lands. So whoever is on the land, he has to make contact with the Lands Commission and they'll take it from there. You get it? Straightforward. Yakubu Awebigo versus Tindana Gungo, very interesting case. The plaintiff is the head of the Awao family in Bogatanga. Pardon me my pronunciations if I don't say the names right. And the defendant is the Tindana, right, the clan head. Now, the land was acquired compulsorily by the state, pardon me for typos, to provide facilities for the bulk oil storage and transportation company limited. The court held that the compensation goes to the allodial title holder for the use and benefit of the members. The prompt payment of fair and adequate compensation, who does it go to? It goes to the allodial title holder. But now, in the interest of the persons in possession of the land, maybe the Usufruct or the lessees on the land, most times, although the compensation is to go to the allodial title holder, the Lands Commission, right, or the appropriate ministry, the Ministry of Lands, the Lands Commission, will actually make contact with those in possession of the land, and if they have to depossess them of the land, they'll pay them compensation. So it's not as if all the money will go to the allodial title holder for him to have a feast. No, you get it. But in this case, is very important too, because it shows us that the allodial title can be vested in the clan. Remember, clan land under section 281 of the 1992 Constitution, the interpretation section, clan land has been interpreted. Go and have a look at that. Then, section 2 also says that allodial title can be vested in the clan. So it's no longer stool land, family land, and skin land. There's also clan land. There's also individual land. And there's also what? Public land. You get it? So allodial title can be vested in the clan. The authority is Yakubu Awebigo versus Tindana Gungo. Under exam stress, we can write Yakubu and Tindana. You get the point. Right, very important. Right, now, the other supporting cases in there I've provided in the Nin Tetelprem the second and Attorney General, Amontia and MD Ghana Telecom Company. Trust me, I've already emphasized on which case is the locus classicus case for compulsory acquisition. These ones are supporting cases. We are done. We are done with compulsory acquisition. So compulsory acquisition, number 1, Article 18. Everyone has the right to own property. Yes, by Article 12, the property can be restricted in the public interest or respect for the rights of others. Yes, we move on. Article 295, public interest. Anything that inures to the benefit of the public. Then we move on. Article 20, compulsory acquisition, that the state can compulsory acquire lands, right, for the public interest. So number 1, it must be by what? A law. It must be by a law. The law must be an executive instrument. Now it must be published, right? Now number 2, it must provide the acquisition is made in the public interest. So number 1 is a law, that is an executive instrument. Number 2 is a public interest. Number 3 is reasonably justified. The justification for the use of the land is that the public interest purpose is more than the private hardship that the private person would endure. Number 4, we are looking at the right to fair and adequate compensation, right, or alternative land. Number 5, what the land will revert to the original owners if it is no longer used in the public interest or for that particular purpose. So even if it's not used for that particular purpose, it will be used in the public interest. If it's used in the public interest, the state will the state would permit that particular use. I hope you got it. That it is still being used in the public interest, so it's still public lands. I hope you got it. Right. All right, so we are done with section 1, section 2, section 3, right? We are going on to section 4. For each section, I have to use about 15 minutes. Is it 7 o'clock? No, we are good to go. We can do section 4. Right, so section 4, the Constitution and foreigners' right to own property. I hope you got it. The Constitution and foreigners' right to own property. So Article 266, ownership of land by non-citizens. Right? I've already explained it. Now, non-citizens are the foreigners. So they cannot own a leasehold for more than 50 years, and they cannot own a freehold. Simple. So foreigners cannot own a leasehold of more than 50 years, and they cannot also own a freehold. Simple. That is it. It's also provided in Section 10 of the Lands Act. Right. So may I put it in there? So just say Section 10 of the Lands Act. The same point is in there. Right. There are certain restrictions on ownership of land by foreigners. This thing is just to be at the back of your mind. And Article 266. Once you see foreigner, you don't just jump to Article 266. No, I've told you the foundation. The foundation is Article 18. Everyone has the right to own property. But what happens to foreigners? Because Article 18 says everyone in Ghana has the right to own property. But Article 17 says that although we are all equal before the law, what our land interests, check Article 17, we are all equal before the law. But Article 17 clause 4, our land interest, that is the land interest of foreigners, can be truncated or restricted in the public interest. Go and check it out, it's there. That means that although we are all equal before the law, although Article 18 says everyone has the right to own property, foreigners have restricted rights. They cannot own property for more than 50 years. Article 266. They cannot own a leasehold for more than 50 years. Article 266. And they cannot also own what? A freehold. Simple. So you don't start from Article 266 and then say Article 266 Section 10. You've lost a lot of marks because the foundation is always in there. Right? The foundation is always in there. Let's quickly move on. So you put in your authorities, you are good to go. Allodial title. First interest in land. Highest and most paramount interest in land. If you don't understand the allodial title, you are going in blind. So let's take our time and do this. Yes, I'll move fast, but I want you to understand this. Let's start. Allodial title. Okay, foundational principle. Let's start from the Constitution. Article 18. Everyone has the right to own property. Right? Property also includes immovable property. Immovable property includes under Section 281, land. Right? Immovable property is land. That is land. So Section 281 defines land. Section 281 of the Lands Act, defines land. It says what? Land includes the surface soil, the buildings, whatever is on the land, including the interests in the land. So if they say everyone has the right to own property under Article 18, it means that you can also own an interest in the land. This is the basis for saying that an individual can also own the allodial title. Because Article 18 says an individual, everyone, either alone or in association with others. Do you remember? So alone means an individual. You get it? So an individual can also own the allodial title. Pardon my pronunciation, you know the case in Yamshire and Afibe, right? You see it in there. We are going to that. So an individual can own the allodial title. A stool can own the allodial title. The state can own the allodial title. A family can own the allodial title. A clan can own the allodial title under Section 2 of the Lands Act. Simple. We are coming to the breakdown. So remember, it is based on what? Article what? 18. Based on Article 18. We will come to that. So, interest in land, Section 1. Right? Right to land is Section 82. We'll come to right to land later when we are dealing with registrable instruments. So, 6 external principles regarding the allodial title. Can we? I think the chats are disrupting you, or let's relax, okay? In the chat, let's move on. And Janine, I'm not the one causing those marks on the screen, so I don't know what's happening. Right? Yes. Let's reduce the texting. It will distract me. It pops up on the screen. Do you get it? Right. So 6 external principles regarding the allodial title. This is what you must remember. Then these are external principles before I come to internal principles. So number 1, the allodial title is governed by customary law. So when you go to Ningo Pampam lands, when you go to the Bogatanga lands, they have different customary rules relating to the allodial title. In some areas, the allodial title is vested in the family. In some areas, the allodial title is vested in the stools. In some areas, the allodial title is vested in sub-stools. In some areas, the allodial title is vested in the clan. So you see, it's according to the customary law, Article 11. Customary law refers to the law that is what applicable to a particular community. Very straightforward point. I hope you got it. So it is governed by customary law. Now, it is distinct by each particular community. Simple. Decided cases on allodial title are based on the custom of that community. So you have to make sure that when you are using a case like Ohimi and Eji, right, he wasn't talking about Volta lands. He wasn't talking about Bogatanga lands. Pardon me for saying Volta lands. That is land that is extremely broad. Pardon me for that. But you get my point, right? So Bogatanga, Kamale, every particular community, customary community, not district, customary community, they have different rules and different customs for their allodial title. You get it? Very straightforward. So it is governed by customary law and not statute or common law. Customary law creates the incidents or rights attached to the allodial title. So the Lands Act only recognizes or guarantees the allodial title. So it is distinct by each particular community in Ghana. Decided cases on allodial title are based on the custom of that community. The court will only apply the custom as a matter of law and use its discretion to determine what is the best representation of the custom. Land Act, the Courts Act, right, ascertainment of customary law. Right. So any question as to existence or content of a rule of customary law is a question of law for the court to determine, not a question of fact. You get it? So yes, so the court can declare what the customary law of an area relating to the allodial title is. So Himi and Eji, they'll declare, right? There are a lot of cases. So move on to section 2. So allodial title, you are starting from Article 18 of the 1992 Constitution. Everyone has the right to own land, right, to an interest in land. Section 281 of the Lands Act says that land includes an interest in immovable property. Now the interest in land, section 1. So it is Article 18, section 281, section 1, section 2. Article 18, section 281, section 1, section 2. All these are points. Answering law questions is the accumulation of marks. Your authorities are the most marks. Right? So when they are marking a question over 25, the area of law and the issues, 5 marks. Analysis and conclusion, 5 marks. So that is 10 marks. The authorities can be as much as or as many as 15 marks. So gather the authorities. Article 18 says this, maybe 1 mark. Section 1 says this, 1 mark. Section 281 says this, 1 mark. Section 2 says this, 1 mark. Section 9, Section 13 of the Lands Act, 1 mark, 1 mark. Because under sources of law, Article 11, it says what? The sources of law, it starts from the Constitution, the Lands Act, subsidiary legislation, before it comes to the case law. So if you are memorizing cases without understanding the constitutional provisions and the Land Act provisions, or memorizing those relevant constitutional provisions and the Lands Act provisions, you are going to lose a lot of marks. That's why someone can answer a question on an allodial title. Then he tells you, please say do allodial title or him and G. The way I used it, he gets 5/25. He doesn't understand why. Because Ohimi and J has no bearing on allodial title, right? It is the Constitution, it's the Lands Act. Yes, Ohimi and J is an old case, it's a foundational precedent, right? But it applies customary law. It's looking at the customary law of that particular area. Talking about stool lands and how the family can have a right to, how the members or the subjects of the stool can have a right to the stool land, the usufructory interest, and how the allodial title in stool lands is acquired. So acquisition of allodial title is not Ohimi and J, it's section 2 of the Lands Act. It states it clearly. Ohimi and J never said allodial title is acquired by compulsory acquisition because it's talking about customary law for stool lands. So you have to be very careful. Start with the Constitution, then you move to the relevant Land Act provisions, then you move to any subsidiary legislation, then move to the case law. You get it? Right. So let's move on. So allodial title. So under section 2 of the Lands Act, allodial title is the highest or ultimate interest in land. It is held by the state or stool or skin or clan or family or an individual. and may have been acquired through compulsory acquisition, conquest, pioneer discovery, or settlement, gift, purchase, or agreement. Now let's look at this compulsory acquisition, Article 20, conquest. Now we have trespass to land. You cannot go into someone's property and conquer the property. They'll report you to the police. There is no such thing as conquest after the 1992 Constitution, right? You cannot go and conquer anyone's land. Pioneer discovery. All the lands have been demarcated in Ghana. You cannot go and discover someone's land. You can only use adverse possession, right? So pioneer discovery or settlement, gift, purchase or agreement. So why were these statements in there? They were in there because what? The law is saying that these are the means by which the allodial title is acquired. I hope you got it. These are the means by which the allodial title is acquired. Right. So, hey, what's happening? All right. So let's have a look at the features of this definition under section 2. Can I restart the sharing so that maybe the marks will go off? They are distracting. Just a moment. All right. All right, so let's go back to it. So I'm done with section 1. I'm done with section 2. So I'm on the allodial title. So now, remember, allodial title, Article 18 of the 1992 Constitution, right? Then we also have section 281 of the Lands Act. Then section 1 of the Lands Act, interest in land. And then section 2 of the Lands Act, right? So under section 2, the allodial title is the highest or ultimate interest in land held by the state or stool or skin or clan or family or an individual, and may have been acquired through compulsory acquisition, conquest, pioneer discovery or settlement, gift, purchase or agreement. Now, you cannot agree to buy the allodial title that is vested in stool or skin lands. I'll come to that under section 9, right? We'll come to that later. So what are the features of this definition under section 2 of the Lands Act? So the Lands Act provision is quite broad. It is just a general provision. It just generally states that the allodial title can be acquired by the state. The allodial title can be acquired by the stool, the skin, the family, the clan. Do you get it? It's general. So more or less, you need to now look at the appropriate sub-provisions dealing with the ownership of that interest. That is the ownership of the allodial title. Of course, the allodial title is acquired by the state, Article 220 of the 1992 Constitution. That is what? By compulsory acquisition. Remember, I already explained it. Now go back to section 281, right, of the Lands Act. So family land, clan land, stool land, tindana, right? They are all defined in there. So section 281 is also so important. That's why I said section 281 is a foundational section. You cannot forget it. Any definition that you want to do and give, your best guess is that it's under section 281. So it says family. Family means a group of persons who trace their ancestry from a common lineage and who, as customary law, are recognized as a land-owning group. You understand? Family land is what? Land, the allodial title to which is held by the family. So when the allodial title is vested in the family, it is family land. When the allodial title is vested in the stool, it is stool land. When the allodial title is vested in the skin, it is skin land. When the allodial title is vested in the clan, it is clan land. When the allodial title is vested in the state, it is public land. You get it? So stool includes a skin and the person or body of persons having control over skin land. Stool land includes any land or interest or right over any land controlled by a stool or skin or the head of a community, right? For the benefits of the subject of that stool or the members of that community or company. So you see, the stool land, right? It's not vested in the stool for the benefits of the stool. It is vested in the stool for the benefits of the Usufruct. So you come to the Usufruct. So stool land, skin land, family land, clan land, they are vested in the stool, the skin, the family, the clan for the benefit of the Usufruct. That's why we go all the way back to, Article 36 clause 8. Right, Article 36 clause 8. So what does Article 36 clause 8 say? It says, the state shall recognize that ownership and possession of land shall carry a social obligation to serve the larger community. And in particular, the state shall recognize that the managers of public land, who are the managers of public land? The Lands Commission, invested in the president, right? The stool and skin land is vested in the what? The chief. And family lands are vested in the heads of families. So all these people are fiduciaries. It is provided for in the Constitution under Article 36 clause 8, and it is also enforced in Section 13 of the Land Act, talking about the fiduciary interest. Remember, if you go to Section 13 of the Lands Act, it says something so important. It says that what the the one who, the stool land, the skin land, the family land, the clan land, right? It is vested in the appropriate to whatever. The person who manages it has a fiduciary duty. A breach of the fiduciary duty will lead to what? A fine or imprisonment. You get it? So that means that the one who is vested in that with the allodial title, the duty of that allodial title holder is to manage the land on behalf of the Usufruct. Those are the beneficiaries. It was stated in the Constitution and Article 36, Clause 8, and it was reinforced in Section 13 of the Lands Act. Management of stool property, management of family property. You start from Article 36, Clause 8 of the 1992 Constitution. Then you move to allodial title, Section 1 and Section 2. So when you move to Section 281, where the allodial title is vested in the stool or skin, it is stool land or skin land. Where the allodial title is vested in the family, it is family land. Where the allodial title is vested in the clan, it is clan land. Now, for stool land, for family land, for clan land, the person who manages it, that is the chief or the family head or the clan head, right? That person is a fiduciary. He's supposed to manage the land for the benefit of the Usufruct or the subjects of the community or the members of the family or the subjects of the clan. So that foundation for the management of stool land, the management of family land, is under Section 13 of the Lands Act and Article 36, Clause 8 of the World Constitution. Any question dealing with management of stool lands, management of family land, the Constitution, Article 36, Clause 8, the Section 13 of the Lands Act. You can also have a look at Section 281 of the Lands Act, and then Section 1 and 2. Because those fiduciaries are fiduciaries because their allodial title is vested in them. But their allodial title is not vested in them for their personal enjoyment. Their allodial title is vested in them for the benefit of the Usufruct. That is why, under Section 9 of the Lands Act, you cannot sell the allodial title. You cannot give a freehold of the allodial title. You can only grant a Usufruct or lease, because lease is not a freehold. So now, under the Lands Act, Section 13, Section 9 of the Lands Act, you can't go to the family head and buy the allodial title. But Section 2 said the allodial title can be acquired by gift or by purchase. So who can gift the allodial title? Who can purchase the allodial title? The person who can gift or purchase the allodial title is the individual who is vested with the allodial title, because an individual can be vested with the allodial title under Section 2. So when an individual is vested with the allodial title, under Article 18, the individual is what? The owner of the land. He can do with the land, he can deal with the land in any way that he pleases. So apart from the individual, the Constitution is saying that where the land is held by the state or the skin or the clan or the family, you are not an individual. You are a fiduciary. You are a custodian. So there is no way that they can sell or transfer the allodial title in stool land or skin land or family land or clan land, because it is for the benefit of the Usufruct. But for the individual, if in a rare circumstance that the allodial title is vested in an individual, he can deal with the land as he pleases. We don't care. But if the allodial title is vested in a custodian, that is the chief or family head or clan head, he cannot deal with the property by selling it permanently, because he's depriving the subject or the Usufruct. It is so important. You must not miss this point. Let's move on. So we are back to the allodial title. Let's quickly just...
Please, can you re-emphasize that point?
Well, I'll come back to it. We've already passed it. Time elements. Thank you. So let's quickly... so we are done with... let me see. Where am I? All right. So let me just go up a bit. Right. So the allodial title can be vested in the state, compulsory acquisition. The stool or skin, they can acquire the allodial title. It's vested in them. That is stool land or skin land. The allodial title can be vested in the clan land. The allodial title can be vested in the family land. The allodial title can be vested in an individual. So the case for individual is Inyamswemshire versus Afibeyin San. It's a landmark case. The court held that after taking evidence and all the way to appeal, the court held that the allodial title in rare instances can be vested in an individual, and that person will be entitled to respect of his title and reversionary rights as the allodial title owners. I hope you got it. Right, family. The allodial title can also be invested in the family. So a member of the family takes the risk of leaving the family settlement to go and explore new lands as a farmer, hunter, or warrior. He settled on a newly discovered land. And now we are talking about hundreds or thousands of years ago. We are not talking about 2015. I hope you got it. No, because now you cannot go and discover new lands in Ghana. The entire territory of Ghana has been demarcated. Wherever the land is, we've divided it into districts and constituencies. You cannot say that you've discovered new land, you've discovered the allodial title. No, there is a stool or skin or clan or family, very probably, that has the right to that particular land. Right. So Amilda and Podia, right? It says that most communities have chiefs, but a good number of chiefs, right, only have jurisdictional titles and not allodial titles. So in Ningo lands, like Ningo Pampam lands, is vested in the what? Family. The lands are vested in the family. That is the case of Amilda and Podia. Clan, the allodial title can be vested in the clan. The clan head is the Tindana. Right, the case I gave was Yakubu Awebigo versus Tindana Agungu, where the Supreme Court has stated that it is clear that since the plaintiff admitted that the defendant is the Tindana of Tindon Sobligo, pardon me for that, and performs the functions of Tindana in respect of Kabio lands, also which are claimed by the plaintiff family as theirs, it follows that since a Tindana holds the land of which is the Tindana in trust for the community of which is the Tindana, the defendant is the Tindana, and consequently the Tindana is the allodial owner of those lands in trust for the families. It follows also that the plaintiff family can only have usufructory title over the lands. So that means that the court is saying that the allodial title can be vested in the family members, pardon me, in the clan. Allodial title can be vested in the clan. So the allodial title can be vested in the sub-stools, Jamestown, Alata Stool, and Simpe Stool. I'm sure you've heard of it, right? The allodial title can be vested in the sub-stools. So there are 3 stools or 3 sub-stools in Jamestown region. That is the Alata, the Simpe, and the Akumaje stools. Right. So the manche is selected from one of the sub-stools and they rotate. Right. So although we have the manche, right, every sub-stool, right, has a allodial title to the land that their subjects are in possession of. So when we want to determine who owns the allodial title, which stool owns the allodial title, we need to know which subjects are predominantly in the area. So if the subject in the territory belongs to the Alata stool, then it's Alata land. If the subject in the territory belongs to the Simpe stool, then it is Simpe land. If the subject in the territory belongs to the Akumaje stool, then it's Akumaje land. You get it? So the other supporting case is Korte and Aswes stool. Right? Korte and Aswes stool. So stools, we can have also the case of Akwe and Awulite. That is dealing with Osu lands. So the plaintiff claimed he got the land from the Osu Manche, and the defendant claimed that he got the land from the Osu Mankwalu. Right? Skin, right? Saka and Dahali. You just read those cases. So the court held in the Ekwe and Awulite that what the Osu Manche is the proper authority to grant Osu lands, because Osu lands are still lands vested in the stool. I hope you got it. Right. So, however, he cannot grant the outskirts land without prior consultation with the heads and elders of the quarters concerned. So that's the point. So the point is that stool lands, right, are vested in the stools. Sub-stool lands are vested in the sub-stools. Right? Clan lands are vested in the clan. Just know the case. If you don't know the case, you can just say Ohime and Iji. It's a foundational principle or a foundational case on allodial title. So if you are in shock, you don't know which case to use, you can just say Ohime Eniji, because it talks about the allodial title and the customary law in general, right? It also relates to the stool land most especially, but then it's still the foundational case for allodial title if you are pressed in using a case. But as I said, under Article 11, the Constitution and the statute carries more weight than the case. You get it? So once you refer to Section 1, Section 2, Section 281 of the Lands Act, you are good to go. But then obviously you can support it with a case. So family lands, we have the case, right? The family lands, the case of Amioda and Podia. Clan lands, we have the case of Yakubu, Awebigu, and Tindana Agungu. Stool lands, we have the case of what? Akwe and Awulite. Sub-stool lands, we have the case of Jamestown, Alata Stool, and Simpe Stool. So you can write all the authorities down. You just be memorizing them. You write all the authorities down. You just be memorizing them. I hope you got it. Right. So those are the particular, that is the people that can be vested with allodial title. Allodial title can also be vested in the individual. Yamsem share and Afibe Isam. Right. Now, acquisition rights and interest of the allodial title. How do we acquire the allodial title? It is Section 2 of the Lands Act. The allodial title can be acquired by compulsory acquisition, Article 20 of the Lands Act. The allodial title can be acquired by conquest, by discovery and subsequent settlement, by gift, by purchase, or by transfer agreement or whatever. Right. You can check that out. So at least the locus classicus case is Ohime in a J. Use Ohime in a J when you're talking about any matter dealing with the acquisition of the allodial title. I think someone is unmuted. Let's mute them. Mute. They're also muted. No babies crying here. This is land law. No Children's Act. Okay, so Ohime and Eji. So you see, you don't need the facts of the case. Just remember the principle. You don't need the facts of the case. Just remember the principle. So Ohime and Eji only stated that there are 4 principal methods by which a stool acquires land. Right? These are conquest and subsequent. You see, it is 2. You get it? So that's why I'm saying that when you are using Ohime and Eji, you have to pay attention to the fact that it is a customary land law case and it's dealing with 2 lands. You get it? So you don't use it as an authority. You say, oh, family lands, Ohime and Eji. No, Ohime and Eji dealt with 2 lands. That's why we use Section 2 of the Lands Act, that it can be vested in the stool, the family, the skin, the clan. So don't just go and be using Ohime and Eji everywhere. But of course, it's a supporting authority. But pay attention to Section 1, Section 2, Section 281, and then Article 18 of the 1992 Constitution. Also Article 36 Clause 8 of the 1992 Constitution. And Article 267 of the 1992 Constitution. That deals with the fact that all stool lands are vested in the appropriate stool. I hope you got it. All stool lands are vested in the appropriate stool. Right. So that's the allodial title. So the allodial title can be, determined by conquest, by discovery, gift, or purchase. You can look at those cases. Is it Imati and Adesia? Right. That is the Yellow Kobo and Mania Kobo. Right. Those who discovered the Kobo Hill or whatever. You get it. Pardon me for saying whatever, but I get the point. Now remember, as I was saying, there's no concept of ownerless lands in Ghana. Right? Wiapa and Solomon. But you don't need these authorities. You have the Lands Act. You get it? Oh, let's mute ourselves. What's happening? You don't have time. I'm even trying to mute the
Colleagues, please.
All right, let's continue. All right, so ownerless lands in Ghana. Right, as I was saying, there's no concept of ownerless land in Ghana. So now you can't say that you've discovered or you're a pioneer discoverer of new land in Ghana. No. We've demarcated the entire territory of Ghana. We know all the boundaries of Ghana. There's nowhere in Ghana that doesn't belong to an allodial title holder. So you don't discover a new place in Ghana. That is the point. So when they say allodial title is acquired by discovery, we are talking about traditional evidence going all the way back to 200 or 300 years ago. If anyone claims that he went to sit on a new piece of land and so he sat there for 20 years and so he acquired the allodial title, that is nonsense. You get it? We cannot discover allodial title today because allodial title is a freehold. It is vested in the custodian of the land. Right? It is vested in the custodian of the land. So even if you sit there for 20 years to pull adverse possession, the person must have knowledge that you're on the land. You get it? Or it's reasonably expected to have knowledge that you're on the land. So we don't go and sit in some forest somewhere and say you've acquired the allodial title by a pioneer discovery. No, it doesn't work. So in Ghana today, you cannot acquire allodial title by conquest. You cannot acquire allodial title by pioneer discovery. And you can also not transfer the allodial title to anyone permanently or perpetually. Right? Especially if it is stool land or skin land or family land or clan land. It is only individual land that is the exception. Check out Section 9 of the Lands Act. Let's read it. Stool, skin, clan, or family land. So the exception is individual land. It says, a stool or skin or clan or family land shall vest in the appropriate stool or skin or clan or family on behalf of an trust for the subjects of the stool. You see, the fiduciary duty, Section 9, Section 13. I'll come to Section 13. Are you getting the point? So look at me again. Article 18 of the 1992 Constitution, Article 267 of the 1992 Constitution, Section 1 of the Lands Act, Section 2 of the Lands Act, Section 281 of the Lands Act, Section 9 of the Lands Act, Section 13 of the Lands Act. Then you've killed the allodial title. Then you use your supporting cases. Any question where the area of law is allodial title. You start from the Constitution, you move to the Lands Act. Then you can use subsidiary legislation, maybe CI 47, maybe representation of the people, bringing, acting in a representative capacity as a chief or something to sue as a fiduciary to protect the land. That is the CI 47, Constitutional Instrument 47, Civil High Court Civil Procedure Rules. That is the subsidiary legislation. Existing law, we have the PNDC or 114, Family Head Accountability Act, reflected in Section 13 of the Lands Act, that now you can sue a stool, a chief or a family head to make him accountable for the disposal or for the use or the funds received from the use of the stool lands or the family lands. But then you must exhaust the customary law procedures, and usually there are certain criteria. Right. The principle is that any allodial title vested in stool land, skin land, or clan or family land is what in the appropriate stool, skin, or clan or family for the benefit of the subject or the members. So it says under subsection 2, a person shall not create an interest or right over any stool, skin, clan, or family land which vests in that person, another person, or a body of persons a freehold interest in that land, howsoever described. You get it? So a freehold interest is a perpetual interest in the land, a perpetual right. I'll come to that later on. You study customary law freehold, common law freehold. You get it? It's perpetual. So you cannot grant a allodial title to someone else. You can only grant Usufruct to a subject or a non-indigene that has stayed on the land for more than 50 years. We'll come to that. I hope you got it. Benefits of the allodial title holder. You can use on him in a G. Right? Ata in Esson, it says, the court held that the allodial title granted the person the right to use and enjoy the benefit of the land. But this is subject to the right of the Usufruct, who is in actual possession of the land. Right? Let me give you some of the benefits. So there are 7 benefits I mentioned. Right? Number 1, the allodial title is the paramount interest. It is subject to no other interest under customary land law administration. So it is the highest interest in land. Under section 50, subsection 21. Section 50, subsection 21 of the Lands Act, the allodial title can even compulsory acquire the Usufruct land, either bare land or this one in farmland, in the communal interest of the particular community. Yes, so that means that the allodial title is the highest custodian or paramount owner of the customary lands. And so what he can even compulsory acquire the land from the Usufruct, as long as it is bare land or it is farmland, and it is needed in the communal interest, and there's payment of compensation to the Usufruct, or giving him alternative land. Yes, so it means that now you can actually interfere with the right of the Usufruct under section 50, subsection 12. You get it? Pay attention to section 50, subsection 12. So the benefits of the allodial title holder. Number 2, the transfer, the enjoyment of the fruits of the land, the settlement and building of the land must be to the knowledge of the allodial title holder. So you see, unless it's a Usufruct, right? But the Usufruct acts on the title of the allodial title holder. Do you get it? So even if the Usufruct is on the land, the allodial title holder still has a reversionary interest. He's called the owner of the land. So the Usufruct must still atone tenancy to the allodial title holder. So you can actually, as a Usufruct, forfeit the land if you don't respect the authority of the allodial title holder. You get it? So if the Usufruct disputes or challenges the authority of the allodial title holder, the Usufruct will no longer get the right to claim the land as his, or to the right of the enjoyment of the exclusive possession of the land. No, he has lost it because he has forfeited his title. He challenged the origin of his title. So you see, that is also under Article 36 clause 8 and section 9. It's saying that the allodial title is vested in the stool, the skin, the clan, or the family for the benefit of the members. So that means that the members have the right to use the land, right, as long as they are acting in interest in accordance with the authority of the allodial title holder. Right? They cannot challenge the allodial title holder. So at time S1, you find the case there. Benefits of the allodial title holder, he's entitled to compensation. You find it there. Article 267, stool and skin lands. All stool lands in Ghana shall vest in the appropriate stool on behalf of an trust and in trust for the subject of the stool in accordance with customary law and usage. I've already explained that. Then it says there shall be established the office of the administrator of stool lands, which shall be responsible for the establishment of a stool land account for each stool, into which be paid all the rent, all the dues, royalties, revenues, or other payments, whether in nature of income or capital from the stool lands. So the allodial title holder collects the revenues, the dues, the royalties, the payments, right? But then he makes account for it. And then, the office of the administrator of stool lands, usually they'll act together. So then there's a percentage sharing, a portion, 10% or so will go to the office of the administrator of stool lands, and then out of the remaining 90%, they'll share it in a certain manner. You get it? But I don't need to memorize all that. Right, let's move on. The marks are still coming. Right, so it says compulsory acquisition in the communal interest. I've already explained it. Right. So section 50 subsection 21, right? It's actually subsection 22 rather. Pardon me. It says the holder of an allodial title shall not take over land under subsection 21. Okay, issue subsection 21 and subsection 22. So without prompt payment of fair and adequate compensation, which in any case shall not be less than 40% of the plot of land or the market value of the plot of land being taken over, or B, providing suitable alternative land where possible to the holder of the usufructory interest. We are done with allodial title. Allodial title, simple. 1 minute summary. When you pick up your pen and the matter or the area of law is on the allodial title, that starts from the Constitution. Under Article 18 of the 1992 Constitution, we all have the right to own property, either alone or in association with others. That means that the individual can also own the allodial title. But in association with others, we can come under a clan or a family or what, a stool or a skin. They can also hold the allodial title. This is shown in Article 267 of the Lands Act. Of the Constitution, pardon me, that says that under Article 267 clause 1, all stool lands shall be vested in the appropriate stool for the benefit of the members of the stool or the subjects of the stool. In fact, you can also have a look at Article 295 of the 1992 Constitution that also defines stool land. Right, stool land, it is the stool that has control over the land, right, for the benefit of the subjects or the members of the stool. So the subjects or the members of the stool are the usufruct. Then you also look at Article 36 clause 8, which also reiterates the same point, that what, when the land is vested in the stool or the skin or the family or the clan, right, they must manage it in the good interest of the usufruct. I hope you got it. They must manage it in the good interest of the usufruct. That's the most important point in there. So anything pertaining allodial title, they are acting a fiduciary duty for the benefit of the usufruct. In fact, section 281 explains land. It says land, right, is any interest in immovable property. And then also section 1 says the interest in immovable property includes the allodial title. Then section 2 says allodial title is this and that and that and that. It's the highest or paramount interest in land. And it can be vested in the stool, the skin, the family, the clan, or the state. When the state acquires allodial title, it is by compulsory acquisition under Article 20 of the 1992 Constitution. The stool, the skin, the family, the clan, the individual, they can acquire the allodial title by discovery and settlement, by conquest, by gift, or by purchase. But now we don't have any concept of ownerless land in Ghana because under Article 4 of the 1992 Constitution, Ghana, the territories of Ghana have been completely demarcated. There's no portion of Ghana that is ownerless. It will belong to the particular stool or skin or clan or custodian in that area. You get it? Right. Now, how do you acquire the allodial title? I've already explained it. So allodial title can be vested in the stool, land, the stool, the skin, the clan, the family, etc. Section 281. It explains family land, stool land, skin land, clan land. Section 9. Because the allodial title is vested in the stool or skin or clan or family, they must manage it in the goodwill for the interest or the benefit of the usufruct. That is the members or the subjects of the allodial title. Now, in that reason, we cannot permanently sell or transfer the allodial title. So that means that we cannot purchase the allodial title because it's a freehold. When you purchase the allodial title, you are depriving the subject of the enjoyment or the use of the allodial title. But you can give a usufruct, right, to the members or the subject or a non-indigene that has been on the land for more than 50 years. You can also give a lease of that particular land, but you cannot permanently transfer the allodial title unless it is individual allodial title. That is the exception, because an individual under Article 18 can also own allodial title, and so the individual can deal with allodial title in whatever means or manner he deems fit. Who wrote IEC? Someone wrote IEC. You see, I put my phone away, and the person wrote IEC. It doesn't make sense.
The person is just childish.
Because I didn't even hold my phone. So obviously someone maliciously wrote IEC to strike fear and panic, assault. You are gone. You're at least 22 years or something. You have an LLB.
Please, their names appear on the screen when they type. So maybe the next time I'll take notes of their names.
Yeah, okay. Because I wasn't even holding my phone or my gadget. So the person took time to write IEC. It's not a coincidence. Yeah, Samu. Elderly.
The person has been doing it deliberately. And
It's
I think we
deliberate.
should
Even
pick
the
the
case
person
counts right
out.
IT.
Yeah.
Let's move on. So we are done with Allodial title. Let's move on to Usufruct. Thank you. Just a moment. I'll stop sharing. Why? We can't have such distractions. Okay.
Yeah, senior. With all apologies, I believe the admin can take those people out because once we follow, we also
No, but
appreciate.
it's distracting the class. So even a lot of people are leaving, or you get the point. So it's very
Yes,
distractive or
and
something.
precisely. This has been brought to the attention of the admins for a long time now, and no action has been taken. So I think that he can stop sharing and we move on to the
Let's move on.
Exactly.
Yes.
All right, so let's move on. Thank you.
Senior, please.
Yeah,
We beg you.
But are
Can you
we
kindly share
going to
the
get it?
screen?
Are we going to
Beg.
get a link? Are
We will
you,
not get it.
No,
Sado? Are you
we
going
will
to
not
help
get
us?
it.
It
Please,
seems
we beg,
whoever is
share it
doing
for
it
us.
doesn't want him to share.
Please share the
Oh,
screen. We beg of you.
please share
Since
the screen for
we are
us.
not
Yes,
sure that
it's
No,
you
a
will
but
share that.
I
it's
don't.
a deliberate disruption of the
Whoever is
program.
doing
Please,
that is
I'm
against
wondering why
sharing.
the administrators
That's why
are
my name
They
is
supervising
should
this
remove the
nonsense.
person from the page. Oh,
Can we mute
I'm
everyone?
pretty much sure those people are from his class. That's why they are doing that. They don't want him
Yes,
sharing
they don't
it.
want him
Neither
to
do they
share.
want us
Relax,
seeing it. But
relax,
it's not
relax,
fair.
Precisely, it's a
relax. Let's
deliberate
mute.
sabotage.
Yes, that's true.
Senior, can you please continue? The other classes, they didn't share their screen, so we can still follow.
Yeah, so this one,
Legis
try
students
to
will not do that,
please.
please. Legis
Because
students
the
will
sharing
not.
is what's
Zuzu girl
interrupting the
saying that.
class.
And what he is doing right now is more helpful to us because we are able to pick the authorities. He's not just talking and dumping whatever, excuse my language, but he's sharing useful content with us.
I'm muting everyone. Let's
thank
continue.
you. Thank you. Mute us.
All right. So we are moving on. So we are now looking at the Usufruct, right? The Usufruct. Now, where do you start from when we are dealing with the usufruct or the usufructory interest? Right, the usufructory interest. Remember, under Article 18, we all have the right to own property. And under Section 281 of the Lands Act, it is very clear that property can also include an interest in immovable property. Then move on to Section 1. The interest in movable property include what? The usufruct. Then the usufruct is under Section 5 of the Lands Act. That's how you are going to do it. But remember, for the purposes of the class, I've always repeated that what the usufruct are the members. They are the ones that are going to enjoy the benefits of the land. In fact, Article 36 clause 8 stated this very clearly, that the usufruct are the ones that the allodial title is working on behalf of. So if the allodial title is two land or skin land or clan land or family land, it is vested in the usufruct. I hope you got it. The allodial title is vested in the usufruct. So it's very, very straightforward. The allodial title is vested, the allodial title is vested in the skin or stool or clan land, but it's for the benefit of the usufruct, the members of the family, the members of the subject of the stool or the skin or the clan. So that's what we're referring to. So that means that under 36 clause 8, Article 36 clause 8, there is the usufruct. Those are the subjects, those are the members. Section 9 also makes reference to the usufruct. If you remember, Section 9 says, a stool or skin or clan or family land shall vest in the appropriate stool or skin or clan or family on behalf of an interest for the subject of the stool or skin or members of a clan or family in accordance with customary law and usage. Right. So that is the usufruct. Those are the subjects. So the authorities for the usufruct: number 1, Article 18. Number 2, Article 36 clause what? 8. Number 3, Section 1. We also have Section 281. We also have Section what? 5 of the Lands Act for the usufruct. Section 5 of the Lands Act for the usufruct. Right. So now let's quickly move on. So it says, so I've provided all those provisions in the write-up. And then we just quickly look at section 5. So it says Usufruct is an interest in land which is A, acquired in the interest of an inherent, acquired in the exercise of an inherent right by a subject or a member of a stool or skin or family or clan which holds the allodial title through the development of an unappropriated portion of the land of the stool or skin or family or clan or by virtue of an express grant. Or B, acquired through settlement for a period of not less than 50 years with the permission of the holder of an allodial title by a non-indigene or group of non-indigenes or the descendant of the non-indigene or group of non-indigenes. Right? And a long write-up. I hope you got it. So, all right, so let's move on. So with reference to the Usufruct, right, with reference to the Usufruct, we are looking at the subject or the members of the clan or family who are entitled to that particular interest in land. I hope you got it. The subject or the members of the clan or family who are entitled to that particular interest in land. So it's just very straightforward. Now, how do the Usufruct acquire that particular interest? So there are 3 types. So we have the express grant, we have the implied grant, and we also have what? The non-indigene. Right. So for the express grant, it means that the Usufruct, who is a member of the family or clan or a subject of the stool or a subject of the skin, right, would approach the chief or approach the family head and expressly request for a grant of a piece of property, either for farming or building or whatever he wants to use on the land. Now, when he approaches the chief in the best interest, right, of the particular family members or the subject of the stool or whatever, will grant an appropriate portion, right, will grant an appropriate portion of the land to the Usufruct. This is known as an express grant. It's simple. It was explained in the Lands Act section 5. It says it is acquired through in the exercise of an inherent right by a subject or a member, right, of a stool or skin or family or clan which holds the allodial title through the development of an unappropriated portion of the land of the stool, skin or family or clan, or by virtue of an express grant. By virtue of an express grant. So that's express grant. So express grant means that the allodial title holder will expressly grant you that particular interest in the land. I hope you got it. So that is by express grant. So that is section 5, subsection 1A, right in there. And then we also have the implied grant. So the implied grant here, it says by virtue or through the development of an unappropriated portion of the land of the stool or skin, right, or family or clan, or by virtue of an express grant. So that means that for the implied grant, so there's a distinction between the implied grant and the express grant. So the express grant is with the express permission of the allodial title holder. The implied grant is the exercise of an inherent right. So where does this inherent right come from? It is from Article 36 clause 8 and Article 267, as well as Article section 2 and section 5 and section 9. Because it says that whatever land is vested in the allodial title, it is for the benefit of the Usufruct. For the benefit of the Usufruct. So if the allodial title is vested in your chief, if you're a member of that community, you have the inherent right to possess an unoccupied portion of the land, farm on it, right? Exercise exclusive possession over it, and then you are deemed to be the Usufruct, right? And the one who is vested with the interest in that land. It's as simple as that. And the third means by which we acquire the Usufruct, right? The third means by which we acquire the Usufruct is by what is known as acquisition by a non-indigene, right? Acquisition by a non-indigene. So with reference to the non-indigene is someone who is not a member or subject of the stool or skin or family or clan, but he has been on the land or he has settled on the land, right, for over 50 years with the permission of the allodial title holder. Now, that 50 years is such a long period of time, right, that you are deemed to become a Usufruct. Now, you have a vested interest in the property. So, by the time the Lands Act came in force, it's recognized that certain people have been on the land for over 50 years. They have a vested interest in the property. You can't just get up and sack them on the ground that because they are not a member of the family or the subject of the stool or the skin, they don't have any right or interest in the property. No, with your knowledge, they've been on the property for more than 50 years. It's like a form of adverse possession, right? You know that under the limitation decree, if someone has been on your land, right, in your knowledge, the person comes innocently on your land or in good faith, and is developing your land or is exercising possession over your land, you have notice of it, you decide to keep quiet for more than a long period of time, right? Usually under the limitation decree, it's like 12 years. You are statute barred. You cannot bring the action anymore. I hope you got it. Right, because the person has now exercised a vested right in the property. So this is a non-indigent. Now, a non-indigent is different from a foreigner. A foreigner is someone who is not a Ghanaian citizen. A non-indigent is a Ghanaian citizen. But a non-indigent is not a member of the family or the stool or the skin or the clan. I hope you got it. Right. So it's very straightforward. So now, of course, you need to make reference to the famous section 281 of the Lands Act. So it says that stool land, right, family land, skin land, clan land. It explains all of it. So it says family land means land the allodial title to which is held by a family for the benefit of the Usufruct. That is the benefit of the members of that family in accordance with customary law. So allodial title is vested in the family, but the benefit is for the Usufruct, the members of the family. So the members of the family are the Usufruct. Stool land includes a skin as well as any person or body of persons having control over stool or skin property. I hope you got it. Pardon me, stool or having control. Stool land includes land or interest in or right over land controlled by a stool, skin, or the head of the particular community for the benefit of the subject of that stool, skin, or members of that community. And then we have clan. I hope you got it. Clan includes a group of families that can be traced to a common ancestor. Then a foreigner is a person who is not a citizen of Ghana, but we also have the non-indigent. So this is a person who is a citizen, but he's not a member of that family or clan. You get it? I've explained express grant. And so the advantages of express grant. When the chief expressly grants you the land, he is able to what? Provide an organization because of the fact that he's able to know where each portion of land has been and who the land has been allocated to. So they're able to demarcate the land properly and they're able to plan, right? So it means there's also proper record keeping because someone will approach the chief or someone will approach the family head for a grant of the land. They'll decide which land is occupied, unoccupied, and then they'll grant that portion of the land. You get it? So there's planning and demarcation for development. There's also prevention of disputes because the boundaries of the lands are clear and right, and you don't need to act in possession of the land before you get the right. The chief has expressly demarcated and granted the right to you in advance. So it generates revenue because now the chief can be able to determine who is on which particular property. When someone is requesting for express grant, the chief can lay a charge that you should maybe provide some snaps, you should provide tenancy or something. Do you get it? Right? So you should give something to atone. You should give something, show some recognition. So that means that in that way, when there's express grant, the chief or the stool will get something in return. This will help to what? Manage the stool properties and then help to sponsor the activities, the cultural activities or the customary activities of the stool or kin. Implied grant. There are also certain characteristics of implied grant. So there are also disadvantages of the express grant. So the allodial title holder, right, that is the chief, because of express grant, he can use it to grant the land to people who are, closely affiliated to him, maybe his direct family members. So there's a chief. When you go for express grant, he rejects you, but then you give it to his family members. Immediately becomes a chief. You expressly grant portions of the land, unoccupied land, to his family members or to his direct affiliates. You get it? So that is a very big disadvantage. But for implied grants, the people can just enter the land. The members of the family can quickly enter the land and possess and start working on the land. I hope you got it. So that is the word implied grant, right? But then we move on to the advantages of the implied grant. So there's idea of equality. Everyone can enter the land. Everyone can have a portion or share. So whatever you can exercise proper dominion over, right, you are good to go. Disadvantages of the implied grant, it will lead to disorganization, lack of uniformity, and all that. So what are the rights of the Usufruct? The Usufruct is entitled to be on the land. He is entitled to enjoy possession of the land. He is not subject to interference with the allodial title holder. Right. The allodial title holder can actually interfere if it's in the communal interest under section 50, subsection 21 and 22. Do you remember? So the allodial title holder can enter the land if it's in the communal interest. That means that it's in the interest of the community to have a grant of the property. To take the property for use for a public interest. You get it? Of that particular community. So the allodial title can interfere. But under ordinary circumstances, the allodial title holder cannot interfere with the rights of the Usufruct or him in a J. That the Usufruct can grant the land to what? Another Usufruct without the consent of the allodial title holder. I hope you got it. But then the Usufruct cannot grant the land to a non-indigene or give a portion of the land to a non-indigene without the knowledge and the consent of the allodial title holder. So lots of Usufruct. I mentioned section 50, subsection 20 to 22. Go and have a look at it. Right. Then also the Usufruct can be disconnected from the allodial title holder. If the Usufruct, right, abandons the Usufruct, he decides to abandon the land. So you've been granted a portion of the land over 10 years, you've never entered that portion. The chief will inform you that you are acting to abandon the particular property. You've been granted a portion of the land, you've decided to contact the chief that you are traveling, and that was it. They never heard from you again. That is it, you get it. So you can also enter the land, act in possession of the land, right? And the after some period of time, you left the land. So in that particular case, you've abandoned the property. It's also forfeiture. So you disconnect by challenging the authority of the allodial title holder. Remember, the allodial title holder under the Constitution, Article 267, if it's two lands, it is vested in the stool or the scheme for the benefit of the members. So, or the subject. So if the subject is challenging the chief or challenging the stool, now the stool doesn't own that property, then how can you claim the usufruct to it? Because you challenge the original title holder. That is basically it. And then also the general case law on acquisition of the usufructory interest. Remember, Oemi and Iji, it talks about the acquisition of the allodial title, but it is acquired in the benefit of for the benefit of the usufruct, right? The usufruct, right, have a right to the allodial title interest. Then we also have the case of this one, Inyam Semshe and Amphibian Sam. That stated that what the allodial title can be vested in an individual, and the usufruct will be vested in anyone that he grants the usufruct to or the member of his family. Mansa and Amua, it says in modern Ghana, a stranger grantee of farming land which he has cultivated has security, like the subject grantee. He has a possessory heritable interest. So long as he continues to discharge his obligations, he cannot be deprived of his interest. So in those days, if the usufruct is going to grant the usufruct to another a non-indigene, it needs the consent and permission of the allodial title holder. Right? That means that the non-indigene too must also be paying tenancy or respecting the cultural authority of the allodial title holder. We have the case of Ewa and Idututu. That particular case held that the allodial title holder is connected to the usufruct. They run their interest side by side. That means that the usufruct is actually the one in exclusive possession of the property. The allodial title holder cannot enter the property and start using the property. No, he cannot interfere with the rights of the usufruct unless it is in the communal interest or unless the usufruct has abandoned or forfeited the particular usufructory title. You get it? Same principle. Obli and Ama, right, shows how the usufruct can be acquired. Right. So the court held that the subject of a stool requiring stool land for its use and occupation does not, generally speaking, require the express permission from his stool. So he can enter the usufructory land, right, on his own. It's an implied grant. He can just enter and start possessing it. So those are the particular provisions in relation to the usufruct, right? As I said, you have a look at Article 18 of the 1992 Constitution, right? Article 267 plus 1 of the 1992 Constitution, right? There are other provisions in there, such as also Article 36 plus 8. Then we have Section 1, Section 281, Section 5 of the 1992 Constitution. Also, we have Section 9. I'll come to that. So now we quickly move on to Section 7. That is the management of stool or scheme property. Thank you. Just a moment. Just give me 10 seconds. All right. So I'm treating a lot of topics. So I chose the order in which I'll treat the topics. Do you get it? So I'll treat freehold and all that, right? So section 7, right? Management of stool or scheme property. Now, as I stated, you start from the Constitution, then you move to the Lands Act, then look at the subsidiary legislation. So let me just give you the clues. The Constitution, right, under the 1992 Constitution, the relevant provisions are the famous Article 18 of the 1992 Constitution. Stool or scheme property. Have a look at it, Article 36, Clause 8 of the 1992 Constitution. That deals with the fiduciary duty imposed on the chief. The Article 267 of the 1992 Constitution, which says that the stool lands are vested in the appropriate stools on behalf of the Usufruct, that is the members or the subjects of the stool, and for their benefit in accordance with customary law. You see, so those are constitutional provisions in relation to stool lands. Then you move on to the Lands Act. The Lands Act, pay attention to Section 1 of the Lands Act, also Section 281 of the Lands Act. It defines stool land for the benefit of the subject of the stools, etc. Allodial title, Section 2. If the allodial title is vested in the stool, then it is stool land. If the allodial title is vested in the skin, then it is skin land. Remember the 1992 Constitution, Article 295. It says that what? The allodial title can be vested in the what? Stool lands is lands that is controlled by a stool. Do you get it? That means that the allodial title is vested in that particular stool. It makes it stool land. So that is it. So I made provisions in the Article 267, 295, Section 281, right? Section 9. It says a stool or skin or clan or family land shall vest in the appropriate stool or skin. Right, so let me read it in relation to stool. It says a stool land shall vest in the appropriate stool on behalf of an interest for the subject of the stool in accordance with customary law and usage. Right, so it doesn't take away the inherent right of a subject of the stool, right, or a member of the clan or family to the usufructory interest in a vacant portion, blah, 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 blah. So that's stool and skin lands. So who is a chief? The chief is the custodian of the stool lands because he is the custodian of the stool. He is the representative of the stool. So the management of the stool land is vested in the chief under Article 277 of the 1992 Constitution. So that's a relevant provision, especially if it deals with administration of stool lands by the chiefs, right? And the one who has the authority to alienate a stool land. If you say the chief has authority to alienate the stool land, then it's Article 277 of the 1992 Constitution. You realize I always emphasize on the provisions of the 1992 Constitution. So Article 277 of the 1992 Constitution defines a chief. It says in this chapter, unless the context otherwise requires, chief means a person who hailing from the dominated family and lineage has, pardon me, so I think it's a mistake. So a person who hailing from the appropriate family and lineage has been validly nominated, elected or selected and installed and skinned or installed as a chief or commander in accordance with the relevant customary law and usage. So there's emphasis on customary law and usage. So the management of stool property, the chieftaincy, right? Anything dealing with the allodial title and usufruct is in accordance with the relevant customary law and usage. That is the law and Article 11 that is applicable to a particular community. Relevant customary law and usage. So yes, the Land Act doesn't really interfere with the petty details. It is customary law. I hope you got it. But the Land Act is just saying that if it is stool lands, you have to manage the stool lands for the benefit of the subject of the stool. Right. Remember, I put in Article 11, Clause 3 in there. So this is the principle in Allodial and Abrams, where Oliniyi stated that the occupant of the stool or head of a family is an indispensable figure in dealing with stool or family land, and there can be no valid disposal of stool or family land without the consent. It is not Olenu that said it now. It is now stated in the Constitution. The Constitution and Article 267 said the stool lands are vested in the stool, and the stool is represented by the chief. So that's what gives the chief the authority. And Article 277 and Article 267, they go together. That means that it is the chief who has been vested with the authority to alienate the stool land. I hope you got it. Right. And if they say alienate, now he's restricted under Section 9 from selling the stool land permanently. He can only grant a lease of the stool land or a usufruct of the stool land or a customary tenancy of the stool land. I hope you are getting me under Section 9. So although he has the authority to alienate it, because you look at the case of Allodial and Abrams, it's a locus classicus case, or Oliniyi. It said the occupant of the stool is an indispensable figure in dealing with the stool land, and there can be no valid disposal of stool land without his consent. Now, the Lands Act has changed that particular principle. The Lands Act is now saying that no, the chief, although he's the one who has the authority, he cannot alienate stool land. He can only grant a lease or a usufruct or a customary tenancy. He cannot grant a freehold in stool land. In the past, they used to sell the stool land until it was abolished in the Constitution. And Article 9 and 1992. So it says, and Article 267, you see there that you cannot grant a freehold of stool land. Have a look at the Kulu J case. I'll come to that. So that means that the family head, I mean, if it's stool land, pardon me, so it's a will of a stool occupant. So if it's a stool land, it is the chief that is the custodian of the stool land. He's supposed to manage it. He's vested with the fiduciary duty. And so the conveyance of the stool land is ineffective without the authority of the chief. Right? Just use Allodial Abrams. Or say according to Lenunji, if you don't remember Allodial Abrams. But as I said, that is just a case. And if you look at Article 11, it's the minimum. So you refer to Article 267 and Article 277 and Article 295 and Article 36 for 8. They all said it, that it is the chief, the one who is vested with the stool land is the chief. He is the one who is supposed to act in the fiduciary duty. Now, the Constitution is saying that in the fiduciary duty, the land is for the benefit of the members, so he cannot permanently grant or sell or dispose of the land. Right. You can also have a look at other cases like Ablo and Sapo, responsibility of the chief in management of stool lands. I've already explained it in Section 9. Section 13 is the fiduciary duty. Right. It says under Section 13, subsection 2. Right. It says a chief, Tindana, clan head, family head. So let's look at chief alone. So a chief, right, in charge of the management of stool or skin land is a fiduciary charged with the obligation to discharge the management function for the benefit of the stool or skin, right, and is accountable as a fiduciary. So you are a fiduciary. So what is the point of a fiduciary? The point of the fiduciary is that he's a custodian. He's not acting for himself, he's acting for the benefit of others. He's a custodian. I hope you got it. He's not acting for himself, he's acting for the benefit of others. I hope you got it. He's a custodian. He's not acting for himself. He's acting for the benefit, right, of others. I hope you got it. Right. So that's the point in there. He's not acting for himself. He's acting for the benefit of others. So in this particular case, what it means is that he cannot, breach that fiduciary duty. So that's why the law is saying that he must be fair. I hope you got it. The law is saying that he must be fair. He must be open. He must be transparent. Right? He must be fair, he must be open, he must be transparent. I hope you got it. Fair, open, and transparent. Right? In the administration of stool property. You get it? So it says the provision of the Head of Family Accountability Act shall apply to this section with the necessary modifications. Now, the Head of Family Accountability Act is simply saying that you can make the Head of Family accountable. Right? You can sue him in the High Court to make accounts for the disposal of land, for the income or the revenue received from the disposal or use of the land, right, to give account of it. So that means that a family member can sue the head of family, make reference to the case of Kwan and Yeni, and I'm sure you've heard of it. Kwan and Yeni, that deals with the fact that if the chief is not going to protect the property, or the principal elders of the family are not acting to protect the property, even a member of the family can bring the action. Now, this case can be applied to the principle, the fiduciary interest principle. So it's a landmark case. Kwan and Yini, pay attention to that. Section 13, Head of Family Accountability Act. So the Head of Family Accountability Act is an existing law, and Article 11. So the Constitution have given provisions. The Lands Act have given provisions. Subsidiary legislation, pay attention to the High Court Civil Procedure Rules. It talks about the chief suing in the representative capacity. So if you are suing in relation to stool lands, you must sue the chief or the regent in the representative capacity. And if it's someone else that has been sued or someone taking the case, the chief or the regent of the particular stool can come and take up that matter. I hope you got it. Right. So there are certain things that you must show before you bring the action against the chief. It says you have to first of all show that you have exhausted the established customary procedure for making the occupant of the stool or skin or the tindana to render account. So you've exhausted the customary law procedure, and then you are qualified under that relevant customary law. Remember, the administration of stool property is in accordance with customary law. I hope you got it. The administration of stool property is in accordance with customary law. So it's a very straightforward point. Now, what are the fiduciary duties of the chief? Just make reference to Section 13. It says the chief, right, must be open, fair, and transparent. And if he breaches that fiduciary duty, he can be arrested, imprisoned, and fined. So that is a duty of loyalty. He must be loyal to the land. Duty of care, duty of account. He must give duty to account. He must give account. Duty to act in good faith. He must act in good faith. Duty of confidentiality. Right? He must protect sensitive information dealing with the land. Duty of stewardship. He must ensure long-term sustainability of stool lands. He doesn't just grant leases on every piece of the property. No, he has to ensure that some of the family members, some of the clan, some of the subjects of the stool are also benefiting. You don't just take stool lands and grant leases, 99-year leases to over 50 people who are not indigenous of the land. No, right? So duty to act within authority, he has to act within the customs, the customary limits, duty of fairness and equity. I hope you got it. So he has to ensure that all the members are fairly and equitably treated. So I've given the constitutional breakdown, Article 267 clause 1, Article 267 clause 2, right? Protection of the future interest by the chief, Article 267 clause 7. It says, clause 5, it says, subject to the provisions of this constitution, no interest in or right over any stool land in Ghana shall be vested, which vest shall be created, which vest in any authority or body of persons a freehold interest, howsoever described. The Lands Act, section 9 clause, subsection 2, right? I already mentioned it. Section 11 says prohibition of discriminatory practice. You can have a look at that. Keeping records of dealing with stool lands, have a look at section 14. These are not major provisions. You can just gloss over it. Right, that is customary, customary land secretariat. Now, the duty to litigate to protect the land. Remember, I made reference to a subsidiary legislation. That is the CI 47. Now, the subsidiary legislation is even above case law. So before Kwan and Yini, before Himin and J, you have to look at the High Court Civil Procedure Rules, Order 409. It says the occupant of a stool or skin, or where the stool or skin is vacant, the regent or caretaker of that stool or skin may sue and be sued on behalf of or as representing the stool or skin. Right? Then you can have a look at the cases Jemfi and Owusu, Bokua and Kumenwusu, Kwan and Yeni. I've already explained the principle in Kwan and Yeni. So you see, pay attention to that. So when it comes to the management of stool property, I always repeat the point. Pay attention to the constitutional provisions, Article 18, Article 267, Article 36 clause 8, Article 295, Article 277, right? I've mentioned Article 36 clause 8. Pay attention to the Lands Act provisions, Section 281, Section 1, Section 2, Section 5, Section 9, Section 13. Pay attention to those particular provisions. Pay attention to the subsidiary legislation. That is the CI 47, the High Court Civil Procedure Rules. That's what the examiners are marking. Before you come to cases, you must get the marks under Constitution, you must get the marks under Lands Act, you must get the marks under the case law. You get it? Under the subsidiary legislation. Then you can use supporting cases. So I know students who have answered constitutional law questions. I know students who have answered land law questions. I know students who have answered criminal law questions. They never use a single case, but they passed. Because they've understood the principle that precedent is always subject to statutes, precedent is always subject to subsidiary legislation, precedent is always subject to existing law, and precedent is always subject to the constitution. So your cases will give you half mark, minimum mark, unless it's a locus classicus case, which means that the case is touching a point that has not been elaborated upon in the constitution. So if the constitution has said something, then you are good to go. The cases will just support the principle. I hope you got it. So we are done with the management of stool property. So we are done with section 7. Let's quickly move on to section 8. Management of family property. That is the same principle, right? That the family property is vested in the appropriate family. Now, family property is not provided in Article 267. Article 267 deals with stool lands. It doesn't deal with family lands. But Article 36 clause 8 says that act in the fiduciary interest. Right. So there's a provision that says that you could not grant freehold in stool lands. And those days you could grant freehold in family lands. Now, Section 9 of the Lands Act is saying that you cannot grant a freehold in stool, skin, clan, or family land. So you cannot permanently deprive the members or the subjects of the stool or the skin or the clan or family of that particular land. So they must have a perpetual right to that land. So you cannot give a freehold, a perpetual interest to anyone else apart from the Usufruct. Do you get it? Right. So because that means that you cannot sell family land permanently. You can only grant a lease to outsiders. And if it's to foreigners, the lease is limited to 50 years. So you can only grant a customary tenancy. You cannot grant a customary law freehold. You cannot grant a common law freehold. You can only grant a usufruct to the member, because it must be for the benefit of the members. So for the management of the family property, we are going to look at the constitutional law provisions. Number 1, Article 18 of the 1992 Constitution. Number 2, Article 36 clause 8 of the 1992 Constitution. No other provision. The rest are dealing with stool or skin lands. Then move on to the Lands Act. Section 1 and Section 281, they always go together. Section 2 talks about the Usufruct, because the Usufruct are members of the family also, right? Family land is also defined under Section 281. When you are dealing with the family, right, usually it is the members of the family that have an interest, right, under Section 281. Then we also have the same duty, Section 9, that you cannot grant a freehold of family land anymore, right? And then we have Section 13, right, fiduciary interest. So that the family head is also a fiduciary. And so the family head must act transparently, openly, fairly. He must also give accounts. He is accountable to the family members. Then we also have PNDC L114. Then we also have the case of Kwan and Yeni, and you are good to go. You are good to go. Once you determine that the area of law is family head, you are good to go. But there are other principles in there. So, Section 8. So I've mentioned Section 281, definition of family land. I've mentioned Amilda and Podia. Remember, Ningo Pampam lands, right, are vested in the family. I dealt with it under the Allodial title. In Nepeku and Ametepe. So those two cases explain that where the Allodial title is vested in the family, it becomes family land, right, to be managed by the head of the family on behalf of the family. This means that members of the family enjoy the benefits of the so members of the family, right, enjoy the benefits of the members of the family. Okay, so family land means land, the allodial title to which is held by a family for the benefit of the members of that family in accordance with customary law. So the allodial title is vested in the family. This means that members of the family enjoy the benefits of the land, which is the usufructory interest, acquisition of family land. So the allodial title is vested in the family. Or in Nigeria, we treated all those cases again. Now there's a distinction between family land and self-acquired property. Right, so the self-acquired property is acquired solely by the individual, but family land is acquired, right, by the members of the family. Now look at it. When you're looking at self-acquired property and then also family property, pay attention to Article 18 of the Constitution. Article 18 of the Constitution said that every person has the right to own property either alone, so you can own property alone, that is self-acquired property, or in association with others, that is what family. So you can own property alone or with your family. You can own property alone or with your family. So yes, there's a distinction between family land and self-acquired property. Now you can have a look at the case of other cases like Heyman and Atipuri, right? Then you can have a look at the principle there. It says where the family holds the allodial title, the members' rights are similar to that of the interest of or subjects of the Stool land. The emphasis is that it must be family property and not the personal or the privately self-acquired property of the deceased or the person, right, or the subject. So that's Heyman and Atipo. So that's the Locus Classicus case, 1957. Pay attention to that particular case, right? Then there are other cases that talk about where the land is acquired by the joint efforts of the family members. It is presumed to be family property. Chechewa and Ekwa, where a member acquired property with a small contribution from the family does not assume the property does not assume the character of family property. So in association with others means that they must all contribute, or there must be a substantial contribution from the members of the family. So if you acquire the land alone, but there's just a very insignificant contribution from the members of the family, then they cannot claim that it is family land. That is Kujo and Kwachi or something, Labi and Kato. You cannot claim that it is family land on the ground that you help the person in school and all that, right? I mean, Saibedu and Ibedu. The nature of the contributions offered, right, by his mother and sister did not constitute substantial contribution. Remember the principle of substantial contribution. You must substantially contribute to the property. But I've told you the Locus Classicus case. Let's quickly move on. The law on the administration of family property. The law on the administration of family property. Starting from Article 18 of the 1992 Constitution, you move on to Article 36 for right? Article 36 clause 8 of the 1992 Constitution says that all lands vested in the family, right, and the fiduciary, right, the family head is the fiduciary. So that means that in any matter concerning the family land, it is the family head that is the fiduciary. I repeat, the family head is the fiduciary. So if you want to sue in relation to the family land, you sue the family head. If the family wants to sue, the family head will sue to the family head. If the family will sue to the family head. So the family head is acting in a representative capacity. This is also provided for under the Lands Act, Section 13. You are a fiduciary. You must be transparent, you must be open, you must be fair. So if you are disposing of the land and right in breach of the interests of the members of the family, you are not a fiduciary, you are not transparent, you are not open, you are not fair. You can be in prison for that. So now a family member, after making him accountable, a family head, right, under the Family Head Accountability Act, you can make him accountable. So Section 13 actually made reference to the Family Head Accountability Act. It said it applies. So now we apply Section 13. We also apply the Family Head Accountability Act. The Family Head Accountability Act says that what a private member of the family, right, with the consent and the concurrence of the other members, can bring an action against the family head, right, to make the family head give account of the use or management of the family, or give information as to what the land was being used for, etc. Right, and they can also cancel any contract that was made in breach of the interest of the family if they act quickly. Do you remember the case? So Ablo and Sapo, that is the landmark case on family land administration. So the principal members of a family cannot give any title in a conveyance of family land, right? It is what the family head. So the principal members of a family cannot give any title or cannot give any title in a conveyance of family land. It is the family head. So the Lands Act, as I said, pay attention to Section 9. The fiduciary duties, the duty of loyalty, the duty of care, is also under a duty to give account. It's under a duty to act in good faith. It's under a duty of confidentiality. It's under a duty of stewardship. It's under a duty to obtain consent. It's under a duty to act within authority, etc. Litigation in reference litigation of family land, as I mentioned, under the High Court Civil Procedure Rule, Order 409. If you don't remember, just see High Court Civil Procedure Rules. Right, it says the head of a family, in accordance with customary law, may sue and be sued on behalf of or as representing the family. Now, remember, I mentioned Kwan and Nieni, right? That's the locus classicus case. It says that if the head of a family is sued as representing the family, but it appears that he or she is not properly protecting the interests of the family, any member of the family may apply to the court to be joined as a defendant. Therefore, there are three main exceptions in Kwan and Nieni dealing with family head being the representative. So where the property is in danger of being lost, then a member of the family can bring the action. Where there is division in the family and no one is interested in bringing an action, then the member of the family can bring an action. Where the head and the principal members are deliberately disposing of the family property, then the member of the family can bring an action. Management of stool or skin property, Section 13. I already made reference to it. And I said that the family head is what? A fiduciary. The family head is a fiduciary. So just remember that the family head is a fiduciary. Right, appointment and removal of family heads. So principle 1. So under the Constitution and Article 17, no person should be discriminated upon, right, on the basis of disability, etc. Right. So under customary law, the appointment of the family head and the removal of the family head is done in accordance with customary law. I hope you got it. So the appointment and the removal of the family head is done in accordance with customary law. I hope you got it. Right. So that means that there are certain customary law principles that regulate it, but it shouldn't be discriminatory. Right. So the locus classicus case is Welbeck and Captain. The question was whether or not the appointment of the second defendant was valid due to the fact that some principal members were not present. Welbeck and Captain. 4 principles from the case. That the appointment of the family head is by the family members. They usually vote, is by selection. Right. It's not heritable. So that means that no one says that I'm born to the original uncle or I'm a son of the Abisambini, so automatically we don't inherit family head. We choose who the head of the family is. It's a serious thing because the head of the family manages and is the custodian of the family property. I hope you got it. So the family heads are appointed by the representatives of the family, usually by vote. So usually there must be a meeting to vote for the family head. So when they are coming to remove a family head too, it must be a meeting that is specifically for the purpose of the removal of the family head. And you must give the family head the right to be heard because it's also human. It shouldn't be discriminated upon. So under Article 19 of the Constitution, you have to give the person a fair trial or a fair hearing. So when you hear that the family head has committed a wrong and they want to remove him, they must inform him and then he must appear. If he decides that he won't appear, that's a different matter. I hope you got it. So there are supporting cases like Latte and Mensa, right? It said, Latte and Mensa, the appointment of the head must be made by all the principal members of the family. The meeting must be convened solely and exclusively for the appointment of the head and not for any other purpose. I hope you got it. You can also look at other supporting cases like Abaka and Ampridu, Banahini and Adinkra, Heavy and Tamaklo and all that. So the accountability of the head of family, I made reference to PNDC or 114. That is the Family Head Accountability Act. So it says a family member can bring a motion before the court to compel the head of the family to render an account. You get it? So the head of family will render an account. So you can sue the head of family. You as a member of the family, you can sue the head of the family. Usually, you are suing on behalf of the family. That means that the head of the family is cheating the family, so you can sue. I hope you got it. Then remember section 13 provides the remedies, right? So basically, we are done with the family head. We are done with 8 sections so far. Thank you so much. I'm moving a bit fast, but I'm using the material, right? So you can just follow with me. The point I'm trying to say is that if there is reference to the family head, right? If you read the question and it's dealing with management of family property, you have to start from the Constitution. Then you move on to the Lands Act. Then move on to the subsidiary legislation. Then move on to the existing law. Then move on to the cases. The Constitution, we have Article 18, Article 36 plus 8. The Lands Act, right? We have Section 1, Section 281, Section 2, Section 5, because Section 2 says allodial title vested in the family. Section 5 to Usufruct. So that's the members, right, who enjoy the benefit. We have Section 9 and then Section 13. So Section 1, Section 281, Section 2, Section 5, Section 9, Section 13. Then also for the subsidiary legislation, the constitutional instrument, the DI 47, that is the Family Head Accountability Act. With reference to the Family Head Accountability Act, we have this particular, that's the High Court, pardon me, so it's the High Court Civil Procedure Rules, pardon me for that, High Court Civil Procedure Rules, CI 47, is dealing with who can sue in reference to family land. Then you also look at the Family Head Accountability Act. That is what an existing law, PNDC or 114. It came before the 1992 Constitution, so it's an existing law. You get it? So I've given authorities for Constitution, the statute, the subsidiary legislation, and the existing law, and the cases. To have given some landmark cases in there, right? Like Ablo and Sapo, Alote and Adams, Abrahams, and all that. Right? You can have a look at that. So now let's look at the common law and customary law field. You're going to have yes, senior.
So please, the allocation of land by the stool and then the
Are we
members
asking
of the
questions
stool.
at the end or the beginning? How did they do it, please?
I wanted to ask to draw a distinction between the void and the voidable. Okay, thank you.
Right. So basically, it is void if it is without the consent or knowledge of the family head. So you cannot alienate family property or deal with family property without the consent or the knowledge of the family head. It makes it automatically void. But if the family head does it, it is not void, but it is voidable. That means that the transaction is legal until the members of the family take active steps to come and avoid it. I hope you got it. The transaction is legal until the members of the family take active steps to come and avoid it. I hope you got it. Right. Any other questions? All right. Yeah.
So that was the stool.
I heard the questions come at the end. Yes, I heard the questions come at the
minute.
end. So let's move on. I'll answer
Sir,
all
the
questions.
question, a minute. This question that we just said about family land, is it the same about the void and voidable? Is it the same situation when it comes to stool land?
Yes, perfectly true. So if the land is dealt with by the chief, right, the transaction is voidable, not void. But if you deal with the land, stool land, without the permission of the chief or consent of the chief, right, it is what void, because automatically you need the consent of the chief. I hope you got it. Right. So section 9, common law and customary law field. Remember. So now remember under Article 18, everyone has the right to own property. Right. Under Article 266, it says that a foreigner cannot own a freehold. So foreigners cannot own a common law freehold. It is now limited to a 50-year lease. I hope you got it. At Peppercorn rent. So a foreigner can only own a leasehold. So you see, there is a distinction between a freehold and a leasehold. A freehold is basically perpetual, right? It is perpetual. So let me just give some of the similarities or the basic attributes. Oh, let's mute. All right. So some of the attributes or distinctions and similarities between the customary law and common law freehold. So there are 6 similarities and 3 main distinctions. So the freeholds are all the same. They are all perpetual. They are inheritable. Perpetual means it is almost it's permanent, right? It's forever. So when I grant you a freehold of the property, I grant you the property perpetually. So it's like you've bought the land and the property from me permanently. It is also inheritable, right? You can inherit the property. It's alienable. It can be transferred. Now, when you have a freehold, you are free from obligations to any other person. So a freehold is like a perpetual interest which you can transfer or inherit. Or you can, give out in any way or manner, or alienate in any way or manner, and you don't perform any obligations to any higher interest. So the allodial title is just a jurisdictional head. It doesn't have any authority over the freehold. That's why now under Section 9 of the Lands Act, you cannot grant a freehold of allodial title property, because the allodial title, right, if they grant a freehold, then the allodial title loses the land interest perpetually. It just has jurisdiction. Jurisdiction means that they just oversee the customary laws of the area. That's the jurisdictional right. They also perform ceremonial activities like festivals and all that. That is jurisdictional right. But you no longer have the right to the use and benefit or exclusive possession of the land. So the one who has the freehold has the right to the use and benefit of the exclusive possession of the land perpetually. But he's not a member of the Stool or family, because that would have been a Usufruct. I hope you got it. And he's also not the original owner. That would have been an allodial title. So a tenancy and a leasehold are for duration. Do you remember? Anything concerning lease, anything concerning tenancy is a duration. So a freehold is not a duration. Customary law freehold is perpetual. Common law freehold is perpetual. So it's not for a duration. So that means that allodial title is perpetual, Usufruct is perpetual, but allodial title is vested in the original owner. Usufruct is vested in a member or someone who is connected to the original owner. So a freehold is basically where a person is not a member or someone who is a Usufruct. I hope you got it. Right. A freehold is not a member of the Usufruct. Do you get it? A freehold, pardon me. So if you are obtaining a freehold to property, you are not a member. Do you get it? Right. And then also you are obtaining it permanently. So there are two types of freeholds. You have the customary law freehold and the common law freehold. So the common law freehold is dealt with by the rules of common law. The customary law freehold are dealt with by the rules of customary law. I hope you got it. So it's very straightforward. So what are the restrictions against the freehold? Section 3, subsection 2. It says the acquisition of customary law freehold in respect of stool skin lands by a foreigner has been proscribed. It has been suspended. Section 4, subsection 2 says the acquisition of common law freehold in respect of stool and skin lands in the non-citizen has been proscribed or suspended. So that means that a foreigner cannot hold the customary law freehold. A foreigner cannot hold the common law freehold. He can only hold the leasehold interest. A citizen can hold a customary law freehold, right? If it's from an individual, he cannot hold a customary law freehold or a common law freehold from what? Stool land or skin land or family land or clan land. Remember Section 9. You cannot have a freehold in stool lands or skin land or family land or clan land. So Section 10 is the restrictions against foreigners. Just go and read it. Section 10, restrictions against foreigners. Remember, I gave Article 266. But Section 9 is very important. Whether you are a Ghanaian citizen, whether you are a foreigner, no one can have a freehold of stool, skin, clan, or family property. You can only have a freehold of individual property, right? You can have a look at the case of S. Parte Kluge, Republic and Regional Lands Officer S. Parte Kluge. The position at the time was that under Article 267, right, of the Constitution, you cannot have a freehold of stool land. But it didn't say you can't have a freehold of family land. So under the Constitution, you could have a freehold of family land. That was the decision in this case. The court held that despite the fact that under Article 36 clause 8 of the 1992 Constitution, there is a statement recognizing the fiduciary responsibilities of family head in management of family property, it does not mean that family heads could not grant a freehold of family property. So in those days, under the 1992 Constitution, you cannot grant a freehold of stool property under Article 267. But there was no restriction against a freehold of family property. However, from 2020, the family right land cannot be granted as a freehold. Pay attention to this. Pay attention to this. Pay attention to this. Thank you very much. So you have a look at all the other supporting cases. You are good to go. So you are done with the freehold interest. I've added some authorities on the list, right? But the main authority is S. Parte Kluge. It says that a freehold, right, could be granted to a family head under the 1992 Constitution. But a freehold in family land could be granted, right, under the 1992 Constitution. But a freehold in stool land could not be granted under the 1992 Constitution. But that principle has changed. Now, in the Lands Act, right? Pay attention to this. In the Lands Act, Section 9, pay attention to this. It says that what? A freehold cannot be granted in stool, skin family or clan property. So the Constitution never made a restriction, and the case of Rule J applied in favor of the freehold acquisition. But now the Constitution, the Lands Act has made a distinction, right? It has now prohibited it. It says that you cannot grant a freehold of skin to land or family property. I repeat things only twice. It shows the emphasis. Let's move on. Family, spousal rights. Thank you. We are now coming to spousal rights. I'm on track. I'll finish before 10 p.m. Spousal rights. Okay, so spousal rights. First of all, as I said, everyone has the right to own property under Article 18 of the 1992 Constitution. Everyone has the right to own property, either alone or in association with others. So you can own property alone, even if you are married. That's the case of a G and a G. You can own property alone, even if you are married. That's the landlord case of a G and G. So look at it. In a J and J, it says a person under Article 18 of the 1992 Constitution of Ghana has the right to own property either alone or in association with others. This means that irrespective of whether the person was married or not, or the property was acquired during the marriage, it is clear that there's a probability that the person remains the owner of the right or interest to the property, the sole owner. So even in marriage, the presumption of joint acquisition can be rebutted. Remember, under Article 22 of the 1992 Constitution, that deals with spousal rights, it stated that it is generally presumed that property acquired after marriage is deemed to be joint property, right? It's jointly acquired property or it's joint property. So when there's property acquired after marriage, there's a presumption that it is joint property. But then it is subject to Article 18. Article 18 is saying that an individual can own property. The fact that you are married doesn't mean that you are no longer an individual. You will always be an individual. So as long as the Constitution says an individual can own property, it means that an individual can own property whilst married. Pay attention. Let's move on. Now, let's have a look at the Article 22. It says a spouse shall not be deprived of a reasonable provision out of the estate of a spouse, whether or not the spouse died having made the will. Right. So with a view to achieving the full realization of the rights referred to, right? I mean, because in reference to Parliament making a law to enact legislation regulating the property rights of spouses. It says, A, spouses shall have equal access to property jointly acquired during marriage. Assets which are jointly acquired during marriage shall be distributed equitably. So the law says assets which are jointly acquired during marriage shall be distributed equitably. This means that the distribution can be fair, right? But you have to prove that the property was jointly acquired. There's a presumption that when the property is acquired after marriage, it is jointly acquired. That's the presumption. I hope you got it. That when the property is acquired after marriage, it is jointly acquired. So when the property is acquired after marriage, it becomes jointly acquired. This means that it will be shared equitably between the parties. However, under Article 18, even whilst married, you can still individually own property. Now, as I said, you always start from the Constitution. The other law in print is the legislation. That is the Matrimonial Causes Act. That is the legislation, Matrimonial Causes Act, Section 19, right, of the Matrimonial Causes Act. It makes provision for financial provision. It makes financial provision for a spouse. So the court may, whenever it thinks just and equitable, award maintenance, pending suit, or financial provision to either party to the marriage. But no order for maintenance, pending suit, or financial provision shall be made until the court has considered the standard of living of the parties and their circumstances. Section 20, property settlement. The court may order either party to the marriage to pay to the other party such sum of money or convey to the other party such movable or immovable property as settlement of property rights or in lieu thereof, or as part of the financial provision. Conveyance of title. When a decree of divorce or nullity is granted, if the court is satisfied that either party to the marriage holds title to movable or immovable property, part or all of which rightfully belongs to the other, the court shall order transfer or conveyance of the interest to the other party. So these are just supporting provisions. Remember that even after the divorce, we can determine that this property doesn't belong to the two spouses, it belongs to this person. The court will order the transfer of the property to that particular person, that's the spouse. So what are some spousal rights? You have the spousal right to divorce. Upon marriage, you also have the right to divorce, right? You have the right to custody of the child, as long as it's in the best welfare of the child. You have the spousal right of freedom from domestic violence. Look at the Domestic Violence Act. But these things are not applicable to land law. Let's look at the spousal property rights. So with the spousal property rights, as I said, you have the right to own property under Article 8 in two types of property: movable property, immovable property. Article 22 right? Article 22 says that any property jointly acquired after marriage is deemed to be what? Jointly acquired property. Any property acquired after marriage is deemed to be jointly acquired property. I hope you got it. Right. So that is immovable property. So section 281, as I said, the land, the interest in land. So you can have a lease. A lease can be jointly acquired. A freehold can be jointly acquired. A leasehold can be jointly acquired. If the allodial title, it can be acquired by the family. Do you remember? Right. Allodial title can be acquired by the family. So there are spousal rights, and there are 5 factors in relation to spousal rights. I've already read it, right? Properties that were acquired before the marriage. I've already read this point. I've already explained a G and a G. So let's move on. So you can see how you can solely acquire property. So although you are married, you can get a property in your own name. So the husband, because I'm a man, I'll make reference to the husband. So the husband, I can be gifted the property. After the exam, someone is buying me a house because the person has passed. I know this person. The person is in the Zoom page. So the person says, "Oh, Seth, do. We are done. I passed, right? I joined your lectures. I passed. I'm giving you this house." Now, obviously, the person is giving me the house personally, right? Even if I'm married, right? It's not jointly acquired property, right? Because it's not the family didn't substantially contribute to it. We didn't act together to acquire that property. I hope you got it. Right. So that is gift, and there's also succession. So I can marry my wife, and then her grandma will pass, and then the grandma would, before the grandma died, the grandma had bequeathed to her certain properties. Now, obviously, right, she was the granddaughter of a grandma, and the grandmother is giving her the properties as the granddaughter, not as a wife. You get it? So that is the individually acquired properties. Then we also have personal loans. I can acquire a separate personal loan where I'm paying for it separately. That is distinct from the joint family account. You get it? I don't need to explain further, but pay attention to that. Now let's have a look at the historical evolution of spousal rights. So number 1, there was the historical basis. Number 2, there was substantial contribution. Then number 3, there was, pay attention. So historical basis, substantial contribution, and then we also have equality is equity, and then we have solely acquired property and fair sharing. Right. So historical basis is that historically they said wives were not entitled to own property right after marriage. It was the husband's property, and they were only entitled to maintenance. Right. That was the general presumption. So a wife is supposed to help the husband. I'm not saying it. It was Ohimin and it was Olinu who said it in the case of Kote and Mate. It's in there. Read it at school. I hope you got it. Right, we have a champion in a champion case that dealt with substantial contribution, the case of a champion in champion. So you also look at equality is equity. So the principle of substantial contribution is that where the spouse is able to show that he or she substantially contributed to that particular property, either in cash or kind, or any form of consideration, then you are entitled to a portion of it. So this was an improvement from the Corte and Mate principle. The Corte and Mate principle was that if you're a wife, you are not even entitled to the property, you are only entitled to maintenance. But now the court is holding, in the case of a champion, and other cases dealing with substantial contribution, that where the party is able to show that he or she has substantially contributed to the property, then it means that he obtains a right to it. But that means that for that particular property, you have to show that you did something. That is, you gave some cash or consideration or something in kind for that property. Right. But I see this is very hard to prove. This is very hard to prove because how will you show the receipts? Especially for wives. They will also give money, but do not have receipts to show. They'll go to the market, they'll trade, they'll bring the money to the husband. And the husband will buy the property in his own name. So how would they show it? That's why we move to the principle of equity. Equality is equity, as stated in the case of Mensa and Mensa, right? We have the 2012 and then the 1998. So there are two different cases. But the principle started after the 1992 Constitution, where the 1992 Constitution said that now there's a presumption that property obtained after marriage is jointly acquired property. So if there's a presumption that property obtained after marriage is jointly acquired property, then it means, right? Then it means that you don't need to show that you substantially contributed to the property. Do you get it? There's presumption rests in your favor, unless the other party is able to show that the presumption should be rebutted. So it's on a case-by-case basis. But in Mensa and Mensa, they provided the principle of equality is equity, that it is best and most equitable to share the property fairly, 50-50 between the parties. unless the party can show what? A private contribution that was more than the other. Right, so that's the presumption of fairness. That the presumption of fairness is equality, that the property should be shared 50-50. I hope you got it. Right, then look at the subsequent cases. That look at it on a case-by-case principle. So they departed from the rule of Mensa and Mensa, that is equality principle. They said you don't need to share the property equally, right? You have to look at the fact of the case, right? It is shared equitably. So it can be shared 70-30, 80-20, 90-10, or 100-0, especially when it is shown that the property is self or solely acquired property. I hope you got it. So that is the relevant point in there. Now we are moving to the Lands Act. I hope you got it. So I was dealing with the Constitution, I was dealing with the cases in relation to the Constitution. But for the Lands Act, right, it says under Section 32, right, a holder of an interest in land may by an instrument transfer that interest in land. I hope you got it. But have a look at Section 38. It says, in the conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance unless a contrary intention is expressed in the conveyance. That means that you see the presumption is that the spouses, where it is property obtained after marriage, both the husband and wives are deemed to be parties to the conveyance. So you need the consent of both the husband and wife, or you need the agreement of the two of them to dispose of the property, unless there's a contrary intention, because it can be rebutted by the evidence. So it is just a presumption. So you can rebut the presumption by showing that maybe there was an agreement or there was already a consent that the husband, I'm saying husband because I'm a man, so I'm just saying it from my perspective. Thank you. So there's an agreement or there's already consent from the wife that I can deal with the property alone, or I can sell the property. So once I've obtained my wife's consent, I can enter into the agreement. So the consent must be in writing, or there can be a contrary intention. The contrary intention is that maybe there's a prenuptial agreement, or there is, a show of facts or evidence that I acquired the property solely. So I said, though, I acquired the property in my own name for my own interest. You get it? I acquired the property in my own name for my own interest. So that is it. So under Section 47, it says, except as provided in sections, subsections in Section 38, in the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, right, or interest in land acquired for valuable consideration during marriage, sell or exchange or transfer or mortgage or lease the land, right, or interest in the land. I hope you got it. Right. So without what? And without the written consent of the other spouse, you can see it down there, which consent shall not be unreasonably withheld. Right. So the consent shall not be unreasonably withheld. So you just need the consent of the spouses. All right. So we are good to go. We have a whole lot of time. I'm going to deal with leases. Pay attention to leases. Pay attention to leases. Thank you. So just give me a minute, then I come to leases. So just give me a moment. Thank you.
Is the teacher not talking?
He asked for a minute, so let's
Oh,
continue.
okay. Thank you.
Yes, he has spoken for long. He may want to save some water.
Can we see him to help us with the notes? Can we?
Maybe they can collect it and send it via whatever means so that we can get it. That will be fine.
I think he's back.
Okay, thank you.
All right, so I've been having back-to-back lectures every day. So more or less, let's continue. All right, so so we are moving on to the next topic. Right, so let me just see how. Let's continue. Right. Okay, so where was I? I'm coming to leases, right?
Yes, please.
All right, pardon me. My truth. So just a moment. So I'm uploading. Let's continue from where we ended. All right. So let's quickly have a look at. I think that is the ninth section or so. Leases. Right. So section 9 or section 10 or so. Just a moment.
Section 11.
Oh, okay. Section 11. Right. So leases. So remember Article 11 of the 1992 Constitution. As I said, we are starting from the Constitution statutes. You can have a look at the Lands Act, the Rent Act, subsidiary legislation, existing law, common law. So for the Constitution, I made reference to Article 18, 12, 295, 266. Remember those particular provisions that I mentioned. So I basically stated that in reference to leases, right, leases is also an interest in property, right, under Section 281 of the Lands Act and Section 1 of the Lands Act. Section 1 of the Lands Act states that a leasehold is also an interest in land. So a leasehold is provided for, I think, under Section 6, right? That is an interest in land. We'll come to that. So Article 18 is very relevant. Now, Article 266 is also important because it says that foreigners cannot have a lease for more than 50 years. So that's a constitutional limitation. Foreigners cannot have a lease for more than 60 years and 50 years. So you quickly move on to the next one. So with reference to the Lands Act 2, the restriction against the foreigners is under Section 10 of the Lands Act. So you find a bit of the restriction there. Section 10 of the Lands Act. So Section 10 of the Lands Act says that more or less a foreigner cannot have a leasehold for more than 50 years. You get it? It's actually void and illegal. So you make reference to Section 10 of the Lands Act when it's dealing with a foreigner. So what is a lease? So a lease is provided under Section 6 of the Lands Act. So number one, it is a lease is a contract, right? It is an interest in land for a duration. It is certain or capable of being ascertained. It arises when a person who holds a Allodial title, the customary law field, the common law field, there is a factory interest, conveys to another person an interest in land for a specified term, subject to terms and conditions. I hope you got it. Right. So in the case of a sublease or an assignment, arise when the holder of a leasehold interest grants a sublease out of the lease, original lease, to the what? The sublessee, etc. So basically, a lease is a contract. A lease is a contract, right? A lease is a contract. So a lease is a contract for a use of the land, exclusive possession of the land for a particular duration. So it is the use of the land for a particular duration. So it is a contract for the use of the land for a particular duration. That is a lease. So, because of the duration element, it cannot be a freehold. So the allodial title is perpetual. The Usufruct is perpetual. The customary law freehold is perpetual. The common law freehold is perpetual. Customary tenancy is just a short-term agreement, right, to use the land, for farming or whatever. That's under, the customary law and usage. But lease is not created under customary law. Lease is actually under common law. Precedent. It is created by precedent. These are the common law cases. Contracts, right? Offer and acceptance, consideration. So all the principles of contracts must be in. So for there to be a valid lease, as determined in the case of Jan and Oru, let's have a look at the case of Jan and Oru. So for a valid transfer, right, the contract must have the full names and identities of the parties. That is in the lease. So in the lease, if the lease is a contract, it must be between two or more. It must be between two or more persons. So this particular lease agreement is a contract between two or more parties. So this particular contract is for a particular purpose between two or more parties. So there's offer, there's acceptance, there's consideration. You get the point. It says the property to be transferred must be fully described with the address or means of locating the property. So you cannot enter into a lease with an unidentifiable property. You cannot say lease of land in Accra. Which portion of the land? Where is the site plan? Where is the exact location of the land? How do we identify this particular property? It was stated in Jan in the rule. The purchase price, so this was dealing with transfer of land interest, but now you can't sell this one, what is in the allodial title and all that. But this was a sale of a house or so. But then obviously the rent, to be the rent or the consideration that must be paid for the lease, right, must be clearly stated. And then they'll have covenants. We have express covenants. The express covenants will be paid and provided for in the lease. And then the signature of the parties. Right. So we'll come to that later. So the first thing you have to understand is that a lease is not created under customary law. A lease is created by contract. A lease is created by contract. A lease is created by contract. So anything pertaining to legal and equitable leases, you can use the Ghanaian case of Jan in the rule. But the point is that a lease is created by contract. And a lease is for a particular duration. A lease is for a particular duration. So it cannot be a freehold. Immediately the duration cannot be ascertained, or we cannot determine what the duration is, then it is not a lease. It is not binding as a lease. A lease is a contract. So under the general rules of contract, it must be in writing with the names of the parties, the description of the land. There are just some slight exceptions under equity, right, that we'll come to. So we will come to that. So it says under section 34, a contract for the transfer of an interest in land is not enforceable if the contract is not evidenced in writing. So lease is an interest in land. So to transfer a lease, that is to transfer an interest to another person for a number of years, to give the person exclusive possession to be on your land for up to 50 years or more. I mean, if it's foreigner, up to 50 years. If it's ordinary Ghanaian citizen, usually they say up to 99 years, because over 100 years it's a bit too long and it will seem perpetual. Do you get it? So we come to that. So more or less, there is under a contract for transfer evidence in writing signed by the person whom the contract is to be proved and the person who is authorized to sign, unless it's exempt under section 36. So why must the lease be in writing? Power evidence rule. It is evidence. I hope you got it. It is evidence. Power evidence rule. So the lease must usually be for a very long duration. 30 years, 50 years, 99 years. Usually, you don't have a 1 year lease. Usually, if it's short term, it can come under equity and under customary or oral contract, right? But usually, a lease is long, 10 years, 15 years, 20 years, 30 years, 5 years, 3 years, right? Or 4 years or something. So because of that, we don't want oral terms. Because with oral terms, you'll not be able to remember and ascertain what were the exact covenants or obligations of the parties. That's why the lease must be in writing, right? And then the terms are easier to prove if the lease is in writing. And then the covenants under the lease are binding on us. You get it? So the covenants under the lease are binding on us because they are written. So when, under the contract rule in Bannerman and Wright, Esso Petroleum and Madden, and also in other cases like Frederick E. Rose and William Pym under contract law, right, where the terms of the contract are all entered into orally and they are reduced into writing, then it means that what is in writing is what is essential. So in order to determine what were the essential covenant obligations of the party, it must be reduced into writing. It constitutes a lease under law. So it must be reduced into writing with the covenant attached. So even though they did not expressly stated all the covenants, the Lands Act under section 50 and 51 also has implied covenants. So you know that on the tenant or on the lessee, right, that is the one who is a tenant of the property, he has an implied covenant to pay rent. He has an implied covenant to adjoining premises, like repair of adjoining premises, not to cause injury to the walls and all that. Do you get it? To pay rent, to not be an illegal or immoral user or commit nuisance on the land. So those are covenants. Right. So there are exceptions to the lease. Just check out the section 36. We move on. So exceptions to the written rule. So if the property is acquired by compulsory acquisition, obviously it is not an ordinary transfer, it's by the state. So it cannot be a written contract between the parties. If it's acquired by operation of law, right, by order of the court, or by will, or by prescription. Prescription is adverse possession. So if the property is acquired by adverse possession, it cannot be what? If the property is acquired by adverse possession, it cannot be in a written agreement, because adverse possession means that you took it because of the lapse of time. The person knew that you're on the land, or was supposed to know that you're on his land. He indirectly consented to you to be being on the land for a long period of time. That more or less is like there's a lapse of time. You cannot no longer enforce. You can't enforce your action against him. You get it? So these are other means that I've put in there by which you can, go against the general principles of a written contract. Right. So any transfer of or conveyance of an interest in land must be by a written contract, unless it comes under these different forms. Right. And then also section 36 provides that what it is subject to equity. So it is subject to equity. It says section 34 and 35 are subject to the rules of equity, including the rules relating to unconscionability, fraud, duress, and part performance. So the point of section 36, subsection 2 is that even if the lease is written in accordance with customary law, it might not be enforceable based on the rules of equity. So they are unconscionable contracts, right? They are contracts that are based on fraud. Unconscionable contracts. Remember CFC Construction Limited in Atisobe. So that's the definition of an unconscionable contract, where you enter into a contract with an illiterate, an old person, an insane person, etc. It's unconscionable. I hope you got it. It's unconscionable because if the terms are harsh and unfair, then it falls under an unconscionable contract. So CFC Construction Limited and Atisobe, right? Then also fraud. Jan and Noru, the court thought that it will amount to fraud to take someone's money to give the person property, then decide not to give the person the property and say he should just take a refund. It will amount to fraud. So that's the case of Jan and Noru. Duress, right? Part performance, right? So I've provided Jan and Noru in the Amuzu and Okleka, Tahiru and Miriku, but the locus classicus case is Jan and Noru. So we have the doctrine of legal and equitable leases. So what this particular doctrine of legal and equitable leases mean is that basically when you enter into a proper lease agreement, a proper lease contract, right, in accordance with the law, in accordance with the Lands Act, this can generate what is known as a legal lease. But an equitable lease is where the party has not fulfilled all the requirements, right? The party has not fulfilled all the requirements. So where the party has not fulfilled all the requirements, then it is an equitable lease. So in this case, the rule is that when you are part performing the contract, for example, when you enter into an agreement or a lease with me for to transfer your property to me for 10 years, but I'll pay rent, right? And then I started paying some of the money, but I didn't finish paying, like pay the agreement or something. Then you decide to cancel the lease agreement. I can sue you for breach of contract. You get it? Because I have an equitable lease, although maybe the agreement was not in writing or signed or deposited at the lands registry for registration and all that, right? I have a right to the property because I started part performance under equity. So section 36 says equity, right, part performance. We also look at fraud or unconscionability or illegality. So in this particular case, the law is just providing, and there are some cases like Sibati and Samuasinge and all that. So we have the doctrine of legal and equitable leases, right? So basically, where you have an equitable lease, it can still be valid and enforceable as long as someone else doesn't have a legal lease that will override your equitable lease. So equity, right, is the equity is subject to the common law. So equity comes to fulfill the law. So equity comes to mitigate the harsh effects of common law. So although you've not fulfilled the harsh effect of a lease, and pardon me, the strong requirements of a lease, although you've not fulfilled it, it will fall under what? Equity. Right. Now, if someone who is a subsequent purchaser, a bona fide purchaser, comes to acquire the same property and is able to show that he had no knowledge of your earlier equity, right, in that same property, then it means that if he's acting in good faith and he has paid consideration, he's a bona fide purchaser and is entitled to the property. I hope you got it. So he's a bona fide purchaser and is entitled to the property. So how do you show that you are a bona fide purchaser? That means you've taken all your necessary due diligence. So you searched the property, you did the physical search, you went to the land registry, you searched, right, the property. You did a search at the land registry, right? You did a physical search, you inspected the property, and you did all your due diligence before you bought the land in good faith. So that means that if someone has entered into a lease agreement or a property agreement, the person must quickly take steps to enter into the property so that he'll be able to show to others that he's on the property. Because there are two types of notices. There is the actual notice and there is also the constructive notice. So pay attention to this. Actual notice and constructive notice. So for constructive notice, the law is that if you are taking due diligence, you would have had notice that someone is on the land or someone has a right to the property if you are taking due diligence. So you cannot claim that you are a bona fide purchaser if you did not have notice. You get it? So the subsequent buyer of the property cannot claim that he's a bona fide purchaser if he was supposed to have constructive notice. Actual notice is when you actually saw the property or actually saw that someone else has an interest in the property and you didn't take due diligence to even investigate, or you acted in bad faith. Because in equity, you must come with clean hands. So if you are coming to plead bona fide purchaser, you have to come with clean hands. You have to show to the court that you did all the necessary due diligence. You inspected the property, you contacted your lawyers, you did the search at the land registry, you did all the relevant works to enable and to ensure that the property is rightfully belonging to the lessor, with no one else having an interest in it. Do you get it? So that is very straightforward. So that is a lease. Those are the rulings dealing with bona fide purchaser and all. I hope you got it. Right. So someone is asking, Senior, can one be said to be a bona fide purchaser without notice when the rival parties to the land have a common grantor or lessor? Well, probably. It depends on the facts, because it depends on the facts of the case. The earlier person, if it's from the same grantor, that means that the grantor was fraudulent. So if both equities, if you are both coming under equity, the first in time will prevail. That is an equitable principle. It's a maximum of equity. That where the parties are equal, the first in time will prevail. So if you ask the grantor and the grantor lied to you, then you, the second person, you can sue the grantor for misrepresentation and get a refund of your money and damages. But you cannot have a right over the earlier person, because the same grantor who granted the land over the earlier person decided to grant it to you. So you are subsequent to the earlier person. And that even if you claim you acted in good faith, if they have to balance the two interests, the one who came first will have a higher interest. You get it? Right. But that means you are both equities. But if you've done due diligence on the land and there's nothing to show that the grantor gave the land to someone else, and in good faith you didn't have notice of any such thing, you did all your relevant due diligence, then you can plead bona fide. I hope you got it. You can plead bona fide that probably you've already entered the land, you've already started acting on the land, you've already paid the consideration. So bona fide purchaser for value without notice. I hope you got it. So that is the structure of the lease. And the next one is on the covenant. I hope you got it. The next one is on the covenant. So the covenant, as I said, there are two types of covenants in a lease agreement. So we have what is known as the express covenant and the implied covenant. So the implied covenants are those that are stated by the Lands Act. You just have to state section 50, section 51 of the Lands Act, and you are good to go. you explain to the examiner implied covenant, section 50 and 51. So section 50 is the implied covenant of the lessor. Section 51 or the transferor. Section 51 is the implied covenant of the lessee, that is the transferee. Right. So what is the implied covenant? So let's do implied covenant first. So implied covenant, section 50, right? So in a conveyance for valuable constitution, there are implied covenants of right to convey, quiet enjoyment, freedom from encumbrances, and further assurance. So just take note of that. So if the landlord is transferring to you the property, he has to show that he has the right to convey or transfer to you the property. He also has to show that there is no other encumbrance that you do not know of. There is no other burden on the property, like a mortgage or a right attached, another person's interest attached to the property. I hope you got it. So you have to show that, right? So there are a lot of things that you would have to show. Do you get it? So more or less, if he has to take further steps to better the title for you, then he has to take those steps to better the title. Do you get it? Right. So that is under section 50. And then section 51 is dealing with implied covenants by the lessee. You just have to take notice of that no matter what is stated in the lease, right? I mean, what was not stated. So if there are no such obligations expressly stated, it is in law stated that the lessee or the transferee, pardon me, is obligated to pay the rent, right? Is obligated to consent or allow for repair to adjoining premises. And in case of making alterations and additions or injuries to the wall, it needs the permission of the lessor, right? In case of any assignment and subletting, it needs the consent of the lessor. Illegal or immoral user, nuisance or annoyance, right, are not allowed on the premises. I hope you got it. So it shouldn't be an illegal user of the premises or an immoral user of the premises, right? You shouldn't commit nuisance or annoyance on the premises. I hope you got it. Then there's also the covenant to pay. So I'll give you cases. So covenant to pay rent. As I said, the Lands Act has already stated it. So the cases are just supportive cases, right? So under the case of Unilever Ghana Limited and Kama Health Services, the court held that parties to a contract might choose a particular currency in order to guarantee to themselves the value of the contract sum, but the ability to pay interest does not depend on what currency was used to denominate the contract. Right? It was dealing with the payment of rent, right? And that they even stated that payment of rent should be in foreign currency and all that. And instead, payment of rent can also be by check or cash, etc. Make certain obligations or statements in relation to payment of rent. Do you get it? So in relation to payment of rent, it is an obligation on the lessee or the tenant to pay the rent, right? It is an obligation of the landlord that he has the right to convey the property. It's an obligation of the landlord that you perfect your title. That is further assurance. It's an obligation on the landlord that will not add any further encumbrance. I hope you got it. There will not be any further encumbrance to the property. So that is just very straightforward. Assignment and subletting, it simply means that you, the lessee, before you assign the remainder of your lease to someone or before you sublet the lease to another person, you need the permission of the lessor, right? So you can use the landmark case of Barclays Bank versus Stool. It says a lessor in considering whether to withhold his consent or not is to act reasonably and not capriciously, but profusely in his own self-interest. So this means that for the lessor, right, when he has transferred the property to you and you want to sublet it to someone else, you need the consent of the lessor. That's like the landlord. But then that consent should not be unreasonably withheld. It was stated in the Lands Act. See, there's the schedule. There's a schedule to the Lands Act that has made more detailed provisions to it. But I just say under the Lands Act. So under the Lands Act, the consent should not be unreasonably withheld. I hope you got it. Right. Then let's quickly move on. So there are other provisions in there. I'll come to the Rent Act later on because I'm going to deal with the next section, landlord and tenant relationship under the Rent Act. So my summary for lease is that what you need to note is that a lease is not a freehold. So Allodial title is a freehold because it's perpetual. Usufruct is a freehold. This is a perpetual interest. Customary freehold, common law freehold, they are freeholds. Customary tenancy is under custom. So the lease is under common law, and the lease is not a freehold. The lease is for a particular duration. The lease is usually under contract. This means that there must be a written agreement signed by the parties with a description of the land and all those particular statements put in there. So description of the land, the covenant, the terms, the obligations of the parties, the conditions, payments of rent and all that. It must be stated in the agreement. However, equity can come in. Sometimes they don't complete the lease agreement, but the party has already paid the money and he has already entered into the property. That is part performance. Also, you are trying to defraud him because you knew that he paid you. You assured him that you go and complete the lease agreement, but never submitted it to him, and you are trying to deprive him of the property. He has a right to the property because he acted in good faith. Then we also explain the doctrine of legal and equitable leases. And I said the landmark case is done in a rule that explains it. And also, you have to just pay attention to the Bonafide purchaser of payment. He paid valuable consideration. He acted in good faith. So this purchaser, although he came subsequent to the equitable holder, if he's able to show that he conducted the necessary due diligence and he entered into the property, he inspected, he checked the lands registry, made a search and all that, then it means that he acted in good faith. And so you cannot deprive him of the property. You also paid the consideration for it. I hope you got it. So you didn't act well or you didn't act in time. Because if you have a lease of property, you have to put something to show that the property is yours. I hope you got it. Right. So I gave certain examples. You can start marking the property or putting trees, economic plans, or putting a caretaker on the land and all that. I hope you got it. Right. So let's move on to landlord and tenant relationship. So for the landlord and tenant relationship, it is governed by the Constitution, it is governed by the Lands Act and also the Rent Act. So basically, the Lands Act is basically dealing with leases. The difference between a lease and a tenancy is that usually lease can also be for bare land. So it can be for farmland, you can lease farmland, you can lease any type of property. But for rent, it must be usually a commercial or residential property. And it's not usually a government building and all that. So there's a distinction between a lease and a rent. Do you get it? So usually when we are dealing with rent, all rents are leases, but not all leases are rent. Just put that at the back of your mind. It can just be a simple, easy question. All rents are leases, but not all leases are rent. Do you get it? So the landlord-tenant relationship is governed by lease and the Lands Act that deals with leases, because a lease can also be a rent, and it's also governed by the Rent Act. So the Rent Act was passed in 1963 at 220. It still has some foundational principles. Now remember, it deals with more or less trying to protect the interest of the tenant, right? So it has concepts dealing with statutory tenants, but what you must remember under the Lands Act is dealing with what is the rules dealing with the ejection of a tenant. So just pay attention to section 17 of the the Rent Act, section 17, recovery of possession by the landlord. I hope you got it. So the landlord wants to eject the tenant. There are certain grounds for ejecting the tenant, right? So if the tenant has not paid rent, you have to come to the rent magistrate to inform the rent magistrate of that particular issue, and the rent magistrate, based on that fact, usually after a month or more of lack of payment of rent with no reasonable excuse, because you can also be a statutory tenant. I'll come to that later on. But if the rent, that is the tenant, is not paying the rent, you can take that as reasonable grounds to eject him from the premises. Obviously, you are entitled to enjoying the benefits of your property under Article 18. Because if you have the right to own property, you cannot own your property and give it to another for free. The person, you can, but if you have rented it out, the person cannot be enjoying your property for free. He has to pay consideration, because whilst he's in the property, he's depriving you from the use of the property. So that is based on Article 18, that because he's depriving you of the use of the property, he has to pay you fair and adequate compensation. I hope you got it. As you've agreed on. Right. So you are saying that the tenant is using the property for immoral or illegal purpose. The tenant is causing nuisance on the property, right? The tenant has not paid the rent. The tenant is not fulfilling the obligations under the rent agreement. I hope you got it. Right. So more or less, these are the relevant provisions in there. Sometimes if the landlord has given notice of the intention, the tenant has informed the landlord that he intends to quit the premises. Right. So he told the landlord that, okay, boss, although I'm renting to December, I need to end the rent in September. I'm traveling. I cannot stay again. So please refund me October, November, December. So the landlord will start looking for someone else. Now, after you've told the landlord and he now wants to evict you because he's gotten someone else, you are telling him that no, you want to remain in the property. He can evict you because you came to notify him of your intention to leave the property. I hope you got it. So all of these ones, they have to usually go to the rent magistrate to order for the ejection. You don't just enter someone's property to remove them. That's the element of statutory tenant. You don't just get up and say, hey, your rent has ended, I'm come to scatter all your stuff. No, it doesn't happen that way. You enter the property, you cause trespass. Even though you are the landlord, once you enter the property, you are causing trespass, because trespass goes against possession. So the tenant, who is a lessee, right, has exclusive possession of the property. The fact that he has not paid the rent for August and September doesn't mean that you can just enter the property and drive him out. No, you need an order from the rent magistrate. I hope you got it. I've heard issues that the rent magistrate haven't been working effectively, or the rent control, those people, they've not been working effectively. But the point is still clear in the Rent Act that although the person has breached the lease agreement and has breached his fundamental obligation or the implied covenant under the lease, it doesn't give you the right to just break into the property and drive the person out. That is actually a trespass, and that is actually a criminal offense, right? Destruction of property and all that. No, so you have to inform the rent magistrate, or you have to go to court and plead that he has breached one of these particular grounds. So you see, this is dealing with commercial property or residential property. All the buildings you see, especially in town, right, where people have rented, these are the relevant rules, and there are even distinctions between the two. So for residential property, the landlord can plead to the rent magistrate that he needs to use the property for himself. He has no alternative place to go, and that it will cost him like greater hardship if he cannot come back into his property. So under certain circumstances, right, if the landlord is able to prove to the rent magistrate that he needs to return to the property for himself or for his family, then in that sense, he's entitled to eject the tenant. So he will not go inside and eject the tenant on his own basis. He has to go to the rent magistrate. So you, the landlord, after you've granted someone a lease agreement of 2 years, like you've rented the property to him for 2 years, after year one, you call him and tell him that, Charlie, I want to come back to my house, so I'm driving you out. No, you are bound by the agreement, unless you can be able to prove to the court that you are working on your constitutional right under Article 18. Your constitutional right under Article 18 basically means that you are working on your right to own property, that this is your property. Yes, you granted it to someone, you gave him exclusive possession, but this is your property. So in case this is your property, what you have to do is that you are pleading that you have to return, or it will cost you unjust hardship. And the hardship that will cost to you is greater than the hardship that will cost to the tenant. That will be cost to the tenant. And that more or less you don't have any other reasonable alternative. You can also plead that this residential premises is needed for your employee or your family member. You have to prove that the employee is someone who, under a reasonable basis, is someone who is expected that you rent a place for him, right? It depends on some kind of jobs. So some kind of works, you need the employee that is close to the vicinity. So if the landlord has a residential building close to the vicinity, he can plead that his employee should be in that building. Or also the family member. The family member is not your is not your cousin or your best friend or your bestie or your external family member. Usually under the law, right, family member was explained. I hope you got it. Right, under the Interpretation Act. So you can look at the case of Nimako and Akibald. So the plaintiff claimed recovery on the ground that he required the house for occupation by himself and his children. He was to live elsewhere with his children and travel some distance, thus suffering. The plaintiff also experienced difficulties in searching for accommodation. The court held that this discomfort and inconvenience can be such as to amount to hardship, right, and may be a reasonable grounds for taking recovery of possession. So this is one of the landmark cases, Nimako and Akibod. As I said, under Section 36, member of the family means the father or mother, wife, husband, child, brother or sister. So the cousin or the nephew or the grandmother or the grandfather are not members of family. So you can't say that you want the property for your grandmother. You can't say you want the property for your grandfather. You get it? No, it must be just husband, wife, child, brother, sister, right, and this one parents. So parents, father or mother, you get it, right? So there are other cases in there. Now if it's dealing with commercial property, right, under the subsection I think the subsection H. Yes, where the lease has expired and the premises are reasonably required by the landlord to be used by the landlord for the landlord's own business purposes. So that means that, or is the landlord wants to what construct the premises being constructed to be used as a business premises. If the landlord has given not less than 6 months written notice. So you see, you don't just get up and sack a commercial this one tenant, right? That is commercial property, the shops, the office buildings, the industries that you've rented and stuff. Right? You don't just get up and sack the person. We have to give him usually about 6 months notice. And you have to usually give a foundational basis for the sacking. You have to show that probably you want to rebuild or renovate the property and all that. Do you get it? So based on that, you just get permission from the rent magistrate, and they allow you to re-enter the property. Okay, so let me do co-ownership for a particular reason. So co-ownership of property. So co-ownership comes about when the property is acquired by two or more people. So when two or more people acquire property, especially spousal rights, right, and Article 22, usually it is presumed that they are co-owners because they acquired it's presumed that they jointly acquired the property. So when two or more people acquire property, they are co-owners. So the co-owners can come under two types. We have the joint tenancy and we have the tenancy in common. That's what you must remember. So you must be able to explain to the examiner that under the concept of co-ownership, this is where two or more persons are holding the same or sharing the same interest in the property, right? So they can be joint tenants or they can be tenants in common. So joint tenants, right, arises when the land is conveyed to two or more people without words to show that they are to take distinct and separate rights. So this is not a division of the interest, right? They are not dividing the interest. What they are doing is that they are saying that they are both holding the complete property jointly. I hope you got it. So they are all holding the complete property jointly. So that is the joint tenancy. You get it. Now, the distinction between joint tenancy and tenancy in common is that for tenancy in common, although the property was granted to them, right, at the same time, right, or more or less, although they acquired the property jointly, right, there is no unity of possession. The land is divided amongst them. There is no unity of title. Each of them has a different title to the property. So he has his different portion. He can sell or deal with his portion anyhow that he deems fit. Do you get it? So that's the tenancy in common. So there are certain things like unity of possession, unity of title, unity of time. You can sell the property in any way that you deem fit. Now, the previous impression of the law was that where under the conveyancing decree, right, where the property is conveyed to two or more persons at the same time, I hope you got it, right? It is generally taken to be what common tenancy in common and not joint tenancy. Do you get the point? So it is tenancy in common and not joint tenancy. It is tenancy in common and not joint tenancy, right? That is the presumption under the old conveyancing decree, and it's the same for the Lands Act. You just need the Lands Act, you just need the Lands Act provision. That is section 40. So section 40 is something that you need to remember. Please remember section 40. It's dealing with tenancy, joint tenancy or tenancy in common. That is co-ownership. It says a conveyance of an interest in land to two or more persons, except a conveyance in trust, creates an interest in common and not in joint tenancy, unless it is expressed in the conveyance that A, the persons to whom the conveyance is made take the interest jointly or as joint tenants, or B, the conveyance is made to them and the survivor of them. So you see, the difference between joint tenancy and the tenancy in common is that there's this rule of survivorship. For joint tenancy, right, if two or more people acquire the same land under joint tenancy, it belongs to all of them at the same time. So basically, the landmark principle is that when the other tenants die, then the sole tenants, the sole remaining tenants, that is the sole survivor, right, will have a full, complete right to the property. Do you get it? So the sole survivor will have a full, complete right to the property. That is just a simple point. That is the main distinction. That's what you must remember. That the difference between joint tenancy and tenancy in common is that the sole survivor under a joint tenancy will have the full right to the property, and it doesn't go to the heirs of the other tenant. It goes to his heirs, right? Those who inherit after him. But with the tenancy in common, we are all having the property in common. So it is shared equally amongst the three of us, or the four of us, or the two of us, or the five of us. So this means that when Kofi dies, his portion of the property will go to his children or those who inherit from him. When Amma dies, her portion of the property will go to her children or those who inherit after her. So the Lands Act is saying that the only distinction between joint tenancy and tenancy in common is the right of survivorship, and also a clear statement that they are taking it as joint tenants. So if there's no such clear statement or no such clear impression of a right of survivorship, then it is a tenancy in common, because a tenancy in common doesn't have a right of survivorship. If you pay attention to the cases, you realize that all these cases occurred before the Land Act 2020. So they are just supporting principles. Using the Land Act is enough. But you can remember, I recommend the case of Inuku and John Teye. It's a landmark case on that. So in this particular case, they acquired the property before 1973. That is before the conveyancing decree. So before the conveyancing decree came in 1973, and before the Lands Act came subsequently after, when they give property to two or more persons, it is presumed to be joint tenancy. And that when one of them dies, or all of them die except the survivor, then the survivor will have the full right to the property, and it will go to his family, not the family of the other people. Do not have a share to it. So you see, it was a bit unjust. Do you get it? Right. That's why tenancy in common is now implemented and was now implemented under the previous law, that is the conveyancing decree, and tenancy in common was also under the Lands Act. Right. So now the Lands Act section 40 is saying that when we acquire property together, even as husband and wife, it is tenancy in common. They will share it. They will share it. You don't say it is joint tenancy and it will go to the family members of the last surviving person. No, they will share it. Do you get it? So you have 50%, 50% share. That was what happened in the Finuku and John Teye case. The issue was that when this one was the name, when they entered the property, right, at the time they got it in 1954, it was in joint tenancy, so it wasn't tenancy in common, and so the party lost the interest to the property, right? So the one that I'm skipping is the registrable instruments, because you treat it in the Ghana School of Law, right? You treat what is known as drafting and conveyancing. So you treat registrable instruments under the Ghana School of Law. So now we are going to have a look at adverse possession. Now remember the principle, equity, the principle under equity, that equity is the vigilant and not the slow, right? Not the slow person. So if you have the limitations decree NLCD 54, it says under section 6, and pardon me, section right, I think that's section 6. Someone should check for me, probably section 7 or something. But recovery of land is limited after 12 years. You get it? So you can't recover landed property after 12. I'll explain. A statute bad. I hope you got it. A statute bad. So yes, equity is the vigilant, not the indolent or the slow person. You get the point I'm saying. So under the limitations decree, after 12 years, you cannot bring a land action, especially when the land rights accrued, and then you knew and you were entitled to bring the action. You decided to wait for more than 12 years. That means you are acting late. You get the point? You are acting late. So that is the matter dealing with adverse possession, right? But this is where it is statute bad. But then for adverse possession, it can also be earlier than the 12 years, right? Now, this is known as the doctrine of acquiescence. So this is where a person has a legitimate land interest and sat down on his right for a considerably too long a period of time, when he knew another person believed he had a legitimate interest in that land and was in possession of it. So you knew, or you're supposed to know, that someone else is on your property. That person is acting bona fide, he's acting in good faith. He believes that he has a right to your property. He has come onto your property. You have knowledge. All you have to do is to inform the person or take action against the person, because it is still based on Article 18. Article 18, you have the right to own property. So that means that if you realize that someone is invading into your property, you have to take legal action to come and protect your property. Because remember, Article 18 is subject to the what? Public interest, and Article 12. Do you remember? So under Article 12, it says that your right is subject to the public interest and also the respect for the rights of others. So if someone in good faith has his own rights and he believes he's exercising his rights over your property, you have to communicate it to the person or take legal action against the person. But if you decide to sit down, especially for the person to remain in your property for a considerably long period of time, and he has been in possession of your property, exclusive possession, without any interference from you, then it means that you have intentionally allowed the person to be cheated, because you want to now come and deprive him of what he has lawfully exercised. after a long period of time, the court will not allow it because you also now have to respect his rights. Because remember, a trespasser can naturally believe that it's a lawful occupation, and he can even sue other trespassers or really do a mim timber. Do you get it? Or really do a mim timber. So a trespasser can also sue other trespassers because he can believe that it's in lawful occupation. He doesn't need to show that he's the owner of the property. He just needs to show that you are a trespasser and he's in lawful occupation. He came before you. So when someone is trespassing on the property and the person genuinely believes he has a claim or right to that property, maybe they sold it to him, but it was under a fraudulent contract. So he was acting in good faith. He paid the money. He enters your property and you decide to sit down. And when you sat down, you saw him develop the property. He built a 5-story building on it. They now go to court that this is your property. You have the land documents, you have everything. They come to drive him out. No, the court will not allow it. Because under equity, you have to be fair. You have to also consider the rights of the other person. And so the court will weigh the balance of interest and the balance of hardship. Why did you sit down after having knowledge? You get the point. So let's read. The case of in Agosai and others and in Probi 32. I hope you got it. Right. So more or less, the court said if the last two stood by and did not challenge the act of the Obojo chief who was dealing with the land as owner, even if the land did not belong to him and his people, I agree with the trial judge that the stool is caused by laches and acquiescence and is therefore stopped by conduct from laying any claim to the whole of, but not only some of the land as subject matter. That's the straightforward point. So the court is trying to explain that look, the stool, right? The stool has, the stool, that's the last stool, had the original right to the property. But they sat down for the Obojo chief to be dealing with the property. And they knew, and they kept quiet. They let him deal with it. He was selling it, he was granting leases, he was granting freehold, a lot of things. It's an old case. It's not really 2010. How because he was granting leases, express grants, Usufruct, and all that. And you sat down and saw it for years. He didn't take action. You are stopped. So this is also known as estoppel, acquiescence and estoppel. So you have to show that there is actual and exclusive possession involving sole occupancy. It's open and visible, and it's a notorious possession. That means that everyone is seeing that someone else has entered the property. Someone else is in the property. So you would have known, or if you took reasonable due diligence on your land, you would have known that someone is on your property. The person has continuous, uninterrupted, and peaceful possession of your property, right? And then now you knew that what you knew that what you had a right to it, but I decided to ignore that right. The court will not allow you to deprive the person of the property. So you can also look at the supporting case, Abbey and Intri, and then there's also Eston versus Yemus, where it was held that on the fact the plaintiff had known of the identity of the defendant for over 40 years. So basically, no action could be brought to recover any land on the expiration of 12 years. I hope you got it. The settled position of the law is that limitation period starts running from the time the person who is in adverse possession or who is being claimed against took possession of the property. So when it is clear to you that someone has taken possession of the property and is acting against your interest, then the time will start running. So you have to take drastic measures to come and enforce your right. Quickly contact a lawyer or enter the property and inform him. I hope you got it. Right. So, more or less, what I'm going to move on to is the last part of the lecture. I hope you got it. Right. The structures. The structures. Okay. How do you answer a question on allodial title? How do you answer a question on Usufruct? How do you answer a question on management of stool property and management of family property? So give me a moment. I'm going to share a material on the structure. All right, so let's do some practicals. It will just be some, I've shared some questions and answers and all. So I think, all right. And I think trespass to land is under tort law, right? So I'm sure your tort law examiner dealt with trespass to land. So compulsory acquisition. So number one, whether the state can acquire land without paying prompt and adequate compensation. That could be a matter in dispute. So if the question, or if you are reading the question, and then the issue is whether or not the state can acquire land without what? Paying prompt and adequate compensation. What you are going to do is what? Number one, you start from Article 18, the right to own property. After moving from Article 18, the right to own property, you move to the fact of Article 12, that property can be restricted in the public interest. Now, when property is restricted in the public interest, the right to own property can be restricted in the public interest. You talk about Article 295. Public interest is what? Anything that inures to the benefit of the public. Then after Article 295, you also move on to Article 20, that the compulsory acquisition, right, is where the state has acquired the land by law, right? That expresses the public interest purpose for the acquisition, and also that public interest purpose, either public morality, public health, public public defense, right, town and country planning and all that. Also under Section 233 of the Lands Act. And then you move on to say that the particular public purpose reason must be justified, right? And then also the rule is that under Article 20 and Section 233, there must be provision for the prompt payment of fair and adequate compensation. Then use the case of Yakubu and Yakubu and Tindana, that deals with what? The payment of compensation. You get it? So that's the landmark case on the payment of compensation. And you are good to go. So you use the constitutional provision, you use the Lands Act Section 233, then you are good to go. So whether or not a person without title but in lawful possession is entitled to compensation. So if a person is in lawful possession of the property, what the law states is that when the state acquires the allodial, when the state acquires the land compulsorily, the state acquires the allodial title. Now, the allodial title is the original interest in the land, the paramount interest in the land. So whoever is on the land must be able to trace his acquisition of the property based on the right or the transfer from the allodial title. So either you're Usufruct, or you have a lease, or you have a customary tenancy, or you have any other interest from the allodial title holder. So that means that you must be able to trace your interest to the allodial title holder, because the state compulsorily acquires the allodial title. If you are a trespasser on the land, you are not entitled to compensation. Whether or not compensation must reflect both the land's market value and disturbance cost. No, the answer is that it must be reasonable, fair, and adequate compensation. What is reasonable, fair, and adequate compensation? Right, the Constitution, doesn't give such a solid breakdown. Now, in reference to the Lands Act, right, if you look at, the relevant sections in the Lands Act, you realize that you cannot plead, more or less, you cannot just determine the kind of compensation that you should be given. Right, yes, it can be a fair value of the land. It will be assessed, that the value of the property will be assessed by the surveyors and the experts and all that, the Lands Commission all. But then the point is that the court is saying that the court will only enforce the payment of fair and adequate compensation. You are not looking at the current market value of the land, which can be very expensive. I hope you got it. Right. Whether revocation is allowed if the land is no longer used for the public purpose. As I said, well, the point is that it can be used for the purpose for which it is acquired, or it can be used for the public purpose. So you still go on in referencing Article 18, Article 12, Section 233, but you come to Article 20, and you say that for public purpose, the land under compulsory acquisition is either used for a public purpose interest or can be used for the general public purpose. That is the non-indigenes and Attorney General. We also have the case of Samoku Jeto, right, etc. So, Samoku Jeto and Lands Commission and Jacob Lamte, that the public interest purpose can change. You get it? So, yes, it can be used for subsequent public interest purpose, right, or different public interest purposes, and doesn't need to revert to the original owners. And also, they don't have revocation. We just have right of first entry. So that means that they will give you the right to apply first, as long as you can repay compensation or give something in value for the land. Then, because they've taken the allodial title from you, so you don't have a right to revoke or right to come and re-enter the property. No, you have to pay compensation. You just have the first right. That is the first option. So that means that you have the option. That means that you'll be the first person to opt. But then they can decide that although they are revoking the public interest, right, it's not going to you because maybe you cannot repay for the value of the land. It's the questions. So the essay questions can generally, you can say, describe the legal frameworks and key statutes governing compulsory acquisition. The structure, as I said, is that under Article 11 of the 1992 Constitution, it is the Constitution, it is the statute, it is the subsidiary legislation, it is the existing law and the common law. So you start from the Constitution. You say that under the Constitution, Article 18, you give the point. Article 20, you give the point. Article 12, you give the point. Article 295, public interest, you give the point. Article 257, when the land is compulsorily acquired by the state, it becomes public land. That's Article 257. Then you move on to the Lands Act. Basically, you just refer to Section 1, Section 281, and also then you just make provision to Section 233 of the Lands Act that deals with compulsory acquisition, and there are supporting provisions that come after. So it says that legal framework, right? The legal framework and all that. Okay, you start from the Constitution, then go to the Lands Act. Then use the cases that I've given. Right, I gave 5 cases. So Samoku Jeto and Jacob Lamte. The second case is also the case of Ni Agusai, Ni Popitetechu, pardon me, and Attorney General, Ni Omambu and Attorney General. We also have the case of Memuna Amudi and Attorney General, and Yakubu and Tindana. So those are the landmark cases. But before you come to the cases, as I said, you also need subsidiary legislation. The subsidiary legislation is executive instrument. That the compulsory acquisition is done by executive instrument. This particular executive instrument must convey the reason for the compulsory acquisition and the purpose, right, of the purpose is justified, right? The necessity for use of the land is justified. It goes beyond the personal interest of the person. I hope you got it, right? Now, the question can also ask you to describe or give an opinion in relation to the government's power, circumstances, and procedural requirements for acquisition. The same thing. Article 18, Article 12, Article 295, Article 20, Article 257. Then now this one, you focus on breaking down Article 2, Article 20 in great detail. So how do you break down Article 20? You mention the 5 points. That number 1, compulsory acquisition is done by law. Number 2, in the public interest. Number 3, there must be reasonable justification. Number 4, there must be the prompt payment of fair and adequate compensation or granting alternative land. And number 5, the first option to re-enter the premises. So you break it down. They must say that under the executive instrument, under Section 233 and Article 20, it must contain, give the right to the person to seek legal measures and legal reliefs. I hope you got it. Right. Then you use the cases too. So rights of landowners, nature and process of compensation. Basically, this one will focus on the compensation, focus on the fact that there must be the payment of prompt, fair, and adequate compensation, right? So, what amounts to prompt, fair, and adequate is determined by the state, but they'll consider the fact, and it must also be in the public interest. Also, the fact is that the compensation usually goes to the allodial title holder, but then it can be shared, right? And they can make account of the use of the land under Section 13, the use of the compensation, and also the Family Head Accountability Act, Section 30 of the Lands Act. So the Family Head Accountability Act is the existing law, right? The subsidiary legislation is the executive instrument, all right? So you can find all that in there. Balance between public interest and individual property rights. So in this particular sense, to determine the balance, you have to determine what the hardship, right? So it must be reasonably justifiable. So for the public interest purpose, you have to show that under Article 295, the land is acquired for it will inure to the general benefit of the public. I hope you got it. It will inure to the general benefit of the public. So that is the point in there. right? Then it also says the government, and also the public interest purpose can change. Remember, so the public interest can override your individual property rights if and only if it will cause you less hardship, right? And the reasonable purpose or necessity for the use of the land is more than what the private right purpose. So you have to explain that the person has the right to enjoy his private property. So you have to show that the hardship that is going to receive from the loss of his property is not greater than the public interest purpose. I hope you got it. Right. Then there can be questions dedicated to spousal rights. So I'm pointing out what will be the general areas if it's dealing with spousal rights, right? How the question relates to. Of course, you have to read the fact if it's a problem question. If it's an essay question, we won't come this straight for it, but this will just be the topic sentence. So problem question for spousal rights. It says whether a spouse is entitled to an equal share of property acquired during marriage. Why is a spouse entitled to an equal share of property acquired during marriage? Number one, Article 22. That says that there's a presumption that property acquired during marriage is deemed to be joint property. But the law never said there's a presumption of equal sharing. The law says that the property must be shared equitably under Article 22. And yeah, it is only property jointly acquired that is shared equitably. So that means that you start from Article 18. Article 18 of the 1992 Constitution says that every person has the right to own property, either alone or in association with others. This means that in marriage, you can own the property alone. So the fact that you are married and the fact that it is property obtained after marriage doesn't necessarily mean that what it doesn't necessarily mean that it is jointly acquired property and that it must be shared equally. So the first one is that you don't have the right to equal share. There's nothing in the Constitution and there's nothing in the Lands Act. Equality is equity is no longer the applicable provision. There is nothing in the Constitution and there is nothing in the Lands Act that says that you have the right to share the property equally. Do you get it? Right? It says equitably. It says equitably. Equitably. So equitably means that the court will consider it on a case-by-case basis. Fin and fin, atta and atta, right? Liter and liter, AJ and AG. You get it? That the court will look at it on a case-by-case basis. Right. So whether property in one spouse's name is considered joint property, we don't come to conclude in that manner. To determine whether or not it is joint property, it's not about whether it is in the name of one person, because the law says that there's a presumption that where the property has been acquired after the marriage, whether it is in the name of Kofi or in the name of Amma, no one cares. As long as the property was acquired after the marriage, there's a strong presumption that it is what jointly acquired property, and that both parties have access to the property and both parties can share the property what equitably. However, you can now bring steps to negate the presumption. So now you must lead evidence to show that it was not jointly acquired property. It was not jointly acquired property because it was solely acquired property under Article 18 of the 1992 Constitution. Then you give your cases. You have your case of MEG in EG, right? That's the authority in there. You have your Article 18, Article 22. You get the point, right? So also there can be a contrary intention that it is public. There's a contrary intention to the rule, or there can be a contrary agreement. Look at Section 38 and Section 47 of the Lands Act, whereby the court held that a contrary intention or consent can show that the person obtained the property alone, or he's dealing with or transferring the property alone. I hope you got it. So explain the property rights of spouses. Pardon me. Number three, whether a homemaker's contribution qualifies for a share in marital property. Yes, because already, if you are married, any property acquired after marriage is deemed to be jointly acquired. So you're entitled to a share. So whether you're working or whether you're a homeowner, you're entitled to the share. This also brings us to the point of equality is equity, as determined by the case of Mensa and Mensa, right? And Carton and other cases, Brafo and Brafo, where the court was saying that now if a person is a spouse that is staying in the house alone, that is staying in the house and taking care of house chores or performing domestic chores and all that, that is known as substantial contribution. Now it is a recognized contribution. I hope you got it. Now it is a recognized contribution. So this is how you answer the question. You use the authorities. Whether inherited or gifted property is subject to distribution upon divorce. What is the answer? No, because it can be solely acquired property. Article 18, Article 22, AG in AG. Essay questions. Discuss the legal rights and duties of spouses under Ghanaian marriage laws, including both customary and statutory provisions. So if they say both customary and statutory, you have to start from what? The Constitution. Then you move on to the statute, that is the Lands Act. So for the Constitution, it is Article 18, Article 22. For the statute, it is the Lands Act. We have Section 36 and then Section 38 and Section 47. You get it? So pay attention to Section 38 and Section 47 of the Lands Act relating to spousal rights. Pay attention to Article 18 and Article 22 of the Lands Act in relation to spousal rights. It says whether inherited or gifted property is okay. I've answered that. So that means that in the case of AG and AG, we can solely acquire property. So by inheritance or by gift, right? That is if it's inheritance or gift to you alone. It's very straightforward. I hope you got it. So I'm just quickly rattling through. I'm trying to point out what are the relevant authorities to use when the questions pop up. Do you get it? And these are any of the questions that will be popping up. So it says under essay questions, right? Discuss the legal rights and duties of spouses. I've already explained it. Explain the property rights of spouses. You get it. Article 18, Article 22. Property rights, you look at the Matrimonial Causes Act. They are also entitled to a fair, equitable distribution of the property. They are entitled to maintenance if possible, or if the facts back it. Right, and they are also entitled to covenants of the property to them or in their name if the facts back it. I hope you got it. Right, you can also use the relevant case law that I've mentioned. So, Corte and Mate, a champion and a champion, Mensa and Mensa, a J and a J. Those are the four landmark cases, locus classicus cases. I hope you got it. It's as simple as that. So, evaluate the impact of different types of marriages. That one won't come. Explain the rights of spouses in relation to it. That one won't come. Foreigner land rights, whether a foreigner can own freehold in Ghana. You start from Article 18. The point is that every person can own land in Ghana. That's Article 18. But Article 12 says it is subject to the public interest and the respect of rights of others. Article 17 says everyone is equal before the law, but a foreigner can be discriminated upon. So you see, the question is whether a foreigner can own freehold land in Ghana. But I started from Article 18, I moved to Article 12, I moved to Article 17, then you move to Article 266, that a foreigner cannot own a freehold in Ghana, right? And any previous freehold that was obtained before 1969 is truncated to what? A 50-year leasehold. Do you get it? So that is how you do the structure. It's very, very, very straightforward. That is how you do the structure. I hope you got it. Right. So it's very straightforward. Now, it says, so whether a foreigner can own freehold in Ghana, I repeat, Article 18, Article 12, then move on to Article 266, and Article 17, Article 266. Then you move on to Section 10 of the Lands Act. Then you conclude that no, a foreigner cannot own a freehold in Ghana. Whether a leasehold to a foreigner can exceed 50 years, you talk about Article 18, the right to own property, by subject to public interest and respect for the rights of others, Article 12. Also, Article 17, although we are all equal before the law, there are certain restrictions against foreigner rights. So that is Article 17. Then you move on to what? The next point. The next point of law is Article 266. That says that a foreigner cannot own a leasehold property more than 50 years. Then move on to Section 10 of the Lands Act. A foreigner cannot own a leasehold for more than 50 years. Then you conclude, based on the authorities above, a foreigner cannot own a leasehold for more than 50 years. Whether a Ghanaian can hold land in trust for a foreigner, this won't come. It will come under equity and trust. It won't come. Whether a foreigner can inherit land in Ghana, it depends. It will come under inheritance. It won't come. I know what is okay. Essay questions. Legal framework governing land ownership and use by foreigners. So you just write the same thing. You just explain. You give an introduction. Then in your main body, you refer to your relevant authorities. Article 18, Article 12, Article 17, Article 266. So for foreigners, it is Article 18, Article 12, Article 17, Article 266, Section 10. Foreigners, Article 18, Article 12, Article 17, Article 266, Section 10. Spousal right is Article 18, Article 12, Article what? Article 22. I hope you got it. That's spousal right. And then spousal right is also Section 38 or so and Section 47. You get it. Allodial title. Allodial title is Article 18, Article 267, Article 295, Article 36, Clause 8. I hope you got it. Right. So whether an individual can own a allodial title in Ghana. Yes, an individual can own a allodial title in Ghana. Which provision says so? Article 18 of the Constitution says anyone can own property. Section 281 of the Lands Act says that land is immovable property or an interest in movable property. Section 1 says an interest in movable property includes the allodial title. Section 2 says the allodial title can be acquired by the individual. Therefore, the individual can acquire the allodial title. Do you get it? Whether an individual can acquire allodial title, Article 18. Then move on to Section 1 and Section 281. That is land, immovable property. Then now move on to what? The next one. So the next one is what? Apart from immovable property, we are also going to have to what am I talking about? Allodial title, right? We are going to have to look at section 2, right? That talks about the allodial title. So the foreigner, the individual can have the right to allodial title. Do you get it? Right. And the case is what Yamswemshire and Afibe Yamswemshire and Afibe. That's the landmark case. Whether allodial title can be transferred outright. Article 18, Article 36, Clause 8. It says that now you're a fiduciary. You cannot transfer the allodial title outright. That is under Section 2. If you look at Yamswemshire and Afibe, that is the case. So Section 2 is on allodial title. Right, but Section 9 says that you cannot grant a freehold of allodial title land except if it's a foreigner. So, pardon me, except if it's an individual. So, if it is stool land, skin land, clan land, or family land, you cannot, transfer the allodial title. So, the question was whether allodial title can be transferred outright. Allodial title for the stool land, skin land, family land, or clan land under Section 13 and Section 12 cannot be transferred outright. Section 13 deals with fiduciary interest. Fiduciary duty. Section 12 deals with section what? 11, right? Section 13 and section what? 9. Section 9. So section 9 says you cannot grant a freehold of allodial title unless it is what? There's two individual property. I hope you got it. Now it says whether or not decisions made by an allodial title holder can override rights of lawful occupants of the usufruct holders. The answer is that yes, in certain situations, if it's provided by the statute. But under customary law, the allodial title goes hand in hand with the usufruct, and the allodial title holder cannot override the rights of the usufruct. I hope you got it right, unless it's in the communal interest under Section 50, subsection 20 to 22. It must be in the communal interest. So the allodial title can override the right of the usufruct if it's in the communal interest. Also, if the usufruct is forfeiting the allodial title, right, is forfeiting its interest by disputing the allodial title. Also, if the usufruct is abandoning the land or going against the allodial title holder. You get it? So it's very straightforward. Whether allodial title holders must register under the Lands Act 2020. Well, allodial title is a customary interest, but it's also a registrable instrument. So you can register it under the Lands Act. But the fact that you've not registered the allodial title doesn't mean that you don't have the allodial title. You get it? The essay questions are relatively similar. Management of stool lands. Let me answer these questions. Whether a chief can alienate stool land without consent of the elders and members. Yes, under Article 36, right? The chief is a fiduciary. Under Section 13 of the Lands Act, the chief is also a fiduciary. Under Section 9, right? The two lands are vested in the chief's right. They are vested in the appropriate stool, right, on behalf of the what? The usufruct, the members and the subjects, right? That's also reiterated in Article 267 and Article 295. You get it? So to answer the question whether a chief can alienate stool land without consent of elders and members, pay attention to Article 295, pay attention to Article 267, pay attention to Article 18, pay attention to Article 36, Clause 8, pay attention to Section 1, Section 2, pay attention to the CI 47. That is the subsidiary legislation. You get it? And then you also pay attention to Section 13 and Section 9 of the Lands Act. Then you conclude that a chief can alienate stool land without consent of elders and members, but they can take quick legal actions to vitiate their particular land. To vitiate the particular transaction or to cause it to be voided. You get it? So they must act what? In time. So that is the Family Head Accountability Act, which under Section 13, it says it's what? It applies to what? The chief. But you have to exhaust, before you come and cancel the contract, you have to show that you have the consent of some of the family members to represent them. You have to exhaust the customary law rules before you come up there. Do you get it? So whether a chief must account to the community, yes, under PNDC or 114 Family Head Accountability Act and Section 13, that is the fiduciary interest, the chief must give account. Under Article 36, Clause 8, it says that the ownership of stool lands is for the public, is for the interest of the subject. So that means that you must account for it. You are a fiduciary under Section 13. As I said, you must be open, you must be fair, and you must be transparent. So to be open, fair, and transparent, you must account for the use of that particular land. Right. Also for stool lands under Article 267, we have the administrator of stool lands. So every income, every revenue, every resources that are acquired from the stool land, right? You must make account to the office of the administrator of stool lands, and then they'll do a proper sharing. I hope you got it. So that is very straightforward. Whether failure to account can justify disbursement. Yes, failure to account can justify disbursement if it is a valid grant under customary law. Right. Then let's move on to family property. The 80 questions are all similar. So family property, the question is whether a family head can alienate family property without consent of principal members. Yes, but the principal in Ablo and Support, right? Is it Ablo and Support, right? But the principal in Ablo and Support, the family head can alienate property without the consent of the principal family members, right? But it makes the contract what? Voidable, not void. So it is voidable. That means that the person can what? Is that an issue? All right, so the question is whether a family head can alienate family property without consent of principal members. Remember, under Article 8, you use the Article 8, and you use the Article 36 Clause 8, right? Then you come to Section 9, and then you also come to what? Section 13. So Section 9 says you cannot alienate the freehold of family land. It is actually in breach of this. It's a criminal offense. It's in breach of the Lands Act. You cannot alienate the freehold in family land. So that means that a family head can transfer family property, but you cannot alienate it, give a freehold to it. I hope you got it right. So if it makes the transfer without the consent and the concurrence of the family members, it's also a breach of his fiduciary duty, because the law is saying under Section 13 that he must be fair, he must be open, he must be transparent. So if there's going to be a transaction, at least he has to form maybe just the principal members at least, or the principal elders of the family. He cannot just get up and grant it. But if he does it, it doesn't necessarily mean that it is an offense or it is a wrong, right? He can later on give account, right? Unless they don't agree, and per the Kwan in Yeni and family head accountability, they decide to take action in the High Court to quash that transaction or to cause the family head to give account for that particular transaction. I hope you got it. So whether or not the sale of family property by one member without authority is valid under Ghanaian law, right? So whether or not the sale of property by one family member without authority is valid, it is void, because he doesn't have the authority to do so. It is void. Do you get it? Right. Whether mismanagement can lead to removal or liability of the head. Yes, mismanagement is actually a ground under Section 13. It's even a criminal offense. And then, as I said, Allodial and Abrams and those other cases, right, you can take steps to remove the family head. So Usufruct, whether Usufruct has the right to harvest the crops. Yes, crops. Usufruct have the right to harvest the crops. They also have an interest in land. It is a freehold interest under Section 5, Section 1. You will see the Usufruct in there. So they give them certain benefits. And also they are the ones who have the right to wreck the land and enjoy the benefits of the land. Whether the usufructory rights can be transferred to a third party, right? Whether the usufructory rights can be transferred to a third party. So now it depends. Now, the third party is a non-indigene, right? So that means that you need the consent and the permission of the allodial title holder. And that indigene, with the consent, if he is on the land for more than 50 years under Section 5, he can what? Get a usufruct to the property too. Whether usufructory is liable for damages beyond normal use. Avoid that question. Whether Usufruct must maintain and protect the land. Yes. So let me see. Whether Usufruct is liable for damages beyond normal use. Unless probably, I don't know how I understand this question, but basically, if he is damaging the property and he's trying to destroy the property, he's going against the reversioning authority of the allodial title holder. So he is forfeiting the property, or is abandoning or destroying the property, obviously. Common law freehold. Whether common law freehold estates can be validly created alongside customary land tenure. No. Whether freehold ownership grants absolute ownership rights over the land. Yes, that's why it's illegal. So freehold in stool, skin, family, and clan land is now illegal. Whether customary law freehold, whether common law freehold. I hope you got it. Right. So customary law freehold in the customary tenancy, leasehold interest, All the answers are in there. So whether a lease must be in writing to create a valid deed, and I have some answers to this question. I've solved almost all possible questions. I've solved a lot of questions, right? I think on our I think there are some answers that are uploaded on our Legis website, but then there's a Legis Google Drive that has all the answers to the questions. The Legis Google Drive has all the answers to the questions. So we've solved actual practical questions, we've solved the answers, and the materials are there for you to download, print, and read. And then we've also given the tables of the facts, the tables of the authorities, the constitutional authorities, the legal authorities to every particular topic, explanation of the principles in the cases. So if you check the land law drive, the law tables, land law, you will find it all in there. I hope you got it. You find it all in there. So it's very, very straightforward. If you check that particular point, so you have the landlord and tenant relationship, acquiescence and prescription. Because of the time element, I'll have to end it here. I hope you got it right. I have to end it here. So thank you so much for joining. Are there any administrators? How do you end it? Thank you so much for joining. Have a wonderful evening. So the Google Drive, I don't know, you have to have access to it. So it has all the answers, especially constitutional law, criminal law, tort law, contract law. It has all the compilations to all the notes that we've been using for our practical, all the answers to the past questions that we've solved and all that, and recordings for each topic. So thank you so much for joining. I have to move a bit fast. I
Yeah,
have
so
4 hours. So how do we?
Good evening. So this
Good
Gloria,
evening.
the organizer.
Okay.
Yes. So I'm grateful to you for this evening's section. I followed through throughout, and I think you've done a very great job. We look forward to tomorrow evening session as well. Thank you. And to all participants, thank you for participating as well. Thank you. Yeah. Good night.
Good night.
Council, I have a question now.
Yeah.
Oh, so Council, so I saw it on the news that Mama has lifted the ban for the sales of state land. I want to see. I don't understand. Like, what does it mean?
Well, all public lands under Article 257. So it starts from Article 8 in Article 257. So under Article 257, right, all public lands are vested in the president. Do you get it? On behalf of and in trust for the people of Ghana. So the president, manages it under the with the Lands Commission. So the Lands Commission manage all the public lands. So once it's state land, that means it has been compulsorily acquired by the state or it belongs to the state, right? Then it means that the president, in the goodwill of the people of Ghana, the president will basically he can direct in the public interest the use of the particular state land. So he has basically given an order that in the public interest under Article 12, there will be no sale of state land because it's against the public interest unless certain criteria are met. So that is just basically it.
So that's why he has lifted the ban now.
Yes, he has lifted the ban. So
okay, thank you.
Council, so how do we get access to the notes?
Well, I'll make contact with the administrators and all that. So thank you.
And please, we'll get it and put it on the page for you guys. Yeah. Thank you very much.
All right, time is of essence.
Thank you so much.
Let's try and get it as quickly as possible. Thank you.
Will.
Thank you. I'm leaving the Zoom page now. Thank you.
Thank you, Council.
Thank you so much.
Thank you so much.
We are so grateful.
Thank you so much, Council.
God bless you. Thank you.
Thank you,
God
Council.
bless
Thank you
you.
very, very
Council,
much.
you are the
We
best.
didn't pray.
Council, you are the best.
Thank you.
Thank you. Thank you. Thank you. Thank you. Thank you.
Amen. Thank you. Do you have any session tomorrow?
Thank you.
Organizer, do you have any session tomorrow? Admin.
Yes, I think the
Yes,
same
I think
lecturer will handle
constitutional
us
law.
tomorrow on constitutional law.
Okay.
The same lecturer will handle us.
Okay.
And
Thank
trust
you very
me, you
much.
can't afford to miss tomorrow's session.
Yeah. Thank you very much. Good night to everybody.
Yes. Good night, seniors.
Night.
Good
Good
night.
night.
Guys.
What a beautiful lecture.
Good night.